Urgent matter.
Court number 10, my lord,
Ah.
matter relating to transfer, my lord. Petitioner has been transferred to a lower court. And the opposite party number, who has transferred the petitioner, he has no jurisdiction, my lord. Can be taken up today, my lord.
Today very difficult. ଆମର ତାଙ୍କ ଆଜି ଅଛି କି ସ୍ପେଶାଲ ନୋଟିସ୍ ଅଛି
Pardon, my lord. Rest TRPC, my lord. Last week I was mentioned a petitioner lady, my lord.
Contractual employees actually before Honorable Justice, we have to mention, my lordship, disciplinary proceeding punishment was imposed, my lord. After I filed the petition on vacation, now they have deducted part of his salary, my lord.
That will come. That is no
No,
urgency.
I only no, my lord. Next week, my lord, again they will deduct salary.
No.
Because
That is no urgency. That will be
not done today.
that will be decided in the writ application. So whatever they have done, it will be subject to result of the writ application. So
Unless, my lord, the interim order is there, again they will deduct from next week.
no, let them. That is no urgency. Yes.
Contractual employees are working since last more than 6 years, my lord. In the meantime, my lord, the Chief Conservator of Forest Wildlife, my lord, issued a letter saying since the petitioner service has not been extended, they may be engaged through service provider, my lord. That amounts to disengagement, my lord. Let it to today acknowledge.
No urgency. Yes.
Item number 30 of weekly list, my lord.
Yes.
I'm supplying a memo, my lord, to withdraw the matter.
Item 30 weekly list permitted to withdraw. Yes.
Tomorrow, my lord.
No. दियंतु मेमो हमें देखिबा.
My lord, the execution proceeding may wind up anytime. And lordship, it's a RSA 2023 matter. The matter was directed to get listed on 9/11/23, but hasn't been listed. Grateful, my lord.
My lord, APL 4747/28/24 press admission. Co-accusation reasonable before this honorable court.
এটা কোন লিস্ট আছে স্পেশাল রাইট ওকে
Sir, out is 10 number court. Sir, what a criminal revision test.
No.
Okay.
My list is completely full, so I cannot.
Item 28, my lord. Can you take it on 1 week after?
Item 28 of which list?
Oh, the supplementary list. The counseling Chelsea mediation. There's a do we have corruption this.
Item 28. When do you want?
1 week after, my lord.
This matter, give a good date. 9th July. Yes.
Supplementary list, item number 1, stress admission.
I plead your words. In this case, my lord, petitioners applied for the post of Shiksha Sir in the year 2016, my lord. And so since he was overage, my lord, they are overage, they approach the honorable court, and by virtue of interim order, my lord, their online offline application was accepted. And thereafter, the list was a prepared, my lord, for giving appointment Shiksha Sahayak, my lord. But thereafter, my lord, their candidature were rejected on the ground of overage, my lord. My lord, the similar matter, my lord, of the 2014, my lord, the batch of cases was, my lord, the enhancing for their age up to 42 years. But here in the year 2016, my lord, the government picked 32 years of age limit, my lord. By virtue of
which reject list you are challenging?
Reject list of 2016, my lord, the prepared, my lord, for engagement of Shiksha Sahayak. That is, my lord, under annexure.
Time bar.
This is third round, my lord. The year 2017, they approached this honorable court.
Okay.
And the year 2023, my lord, they approached this honorable court. The 23, my lord, this order was passed, my lord. By virtue of that order, my lord, they submitted a representation before the government, my lord, for consideration of their case with reference to the case of Babita Satpathy case, my lord. WS 701 of 2019.
To pursue the representation submitted by the petitioner on Annexure 1.
Annexure 6 series is there.
There is no liberty granted, no direction issued to consider the representation, only withdrawal was allowed.
My lord.
Observing that you may pursue your
Pursue,
representation.
my lord.
So you have pursued your representation. What is the outcome of that representation?
Thereafter, they pursue my lord, annexure 6 series, my lord.
Yes.
They pursue the representation and 6.
So what happened? What happened to this representation?
Thereafter, my lord, nothing, no communication has been made, my lord.
Well, let them consider it. What do you say, Mr. Patel?
Yes.
No, no,
With
what?
respect to this consideration of the representation, I do not have any given. But as your lordship pointed out,
There was no direction as such.
what is the date of the rejection list and which is impugned here?
It is 2016.
Nothing has been impugned. Even that has not been impugned in this case.
Yes. So they only want a direction to the opposite
And part is
party.
that particular decision of this honorable
Well,
court.
anyway,
Yes.
they claim to have submitted some representations. Let it be considered for whatever
Yes.
worth.
Yes.
The limited grievance of the petitioners. Petitioner বোধহয় না
Petitioners, my lord. Petitioners.
কেজন
So they say
30.
petitioners
17.
is non-consideration of the representations submitted by them to the Commissioner cum Secretary, Department of School and Mass Education, Odisha. Being aggrieved by the rejection of their candidature for Shiksha Sahayak in the year 2016, the petitioners had approached this court in WPC number 4745 of 2023, which was withdrawn, which was permitted to be withdrawn by the order dated 27/2/2023. Stop. The coordinate bench of this court, while passing the order, had observed that the petitioners would pursue the representations submitted by them to the Commissioner cum Secretary, School and Mass Education Department. Sri Satpathy Learned Counsel for the petitioner draws attention of the court to the bunch of representations enclosed collectively as Annexure 6 series, which appear to have been submitted on different dates. He further submits, no action whatsoever has been taken on such representations. Stop. Such being the case, the writ application is disposed of, directing the Commissioner cum Secretary, School and Mass Education Department to consider and dispose of the representations of the petitioners, if not already disposed of in the meantime, by passing a reasoned order. Yes, within a period of 2 months, within 2 months from the date of production of certified copy of this order by the petitioners. Yes.
Right.
Please, your lordship. Lord, the petitioner lost a check in his room while he left Bhavanipadna from his school, and that check was being misutilized by the opposite party number 1, my lord. The lordship may kindly come to my page 5 of my TRP.
Yes.
Sir, the innocent petitioner file is under threat. If he travels to Bhavanipadna, it would be impossible on his part to defend his case before the Long Trial Court, SDGM Bhavanipadna, as it is pertinent to mention the local goons at the behest of complainant are in a mood to spoil the life of the petitioner. On that score, the petitioner paid before this honorable court for transfer of the criminal case, 1cc case from SDGM Bhavanipadna to any other court your lordship deemed fit and proper. Your lordship may kindly see the complaint petition under Annexure 1, your lordship.
Yes.
Your lordship may kindly see the under Annexure 1, page 11. That as per the request of accused person, the complainant supplied iron chair and table for the educational institution of the accused persons of worth rupees 30,000. Nowhere they have stated whether they have supplied with requisition, whether they have supplied with the
That is different matter. That is why are you submitting on merits? It is to be decided in the case, but I find no reason to transfer. This is no ground for transfer. If you are apprehending threat to your life, you can approach the police. You can also file an appropriate application in the court. No,
Miller, may kindly come to my reply to the OP1.
Sir, this is a reply to the demand notice. How is it relevant for transfer? How is it relevant for transfer? This is your defense in the case. You have to pursue the your case. That's all.
Your Lordship, may kindly allow me on virtual, I will.
Virtually you can. You don't have to appear every day. You don't have to appear. You can file an application for 205 also.
I have already filed, my lord.
So has that been allowed?
Yes, my lord.
If that has been
That has been allowed in the last month, your Lordship.
maybe. So why are you?
Your Lordship, may kindly allow me to address the court on virtual, my lord.
No. Virtual. You see, this is a complaint case. You don't have to address the court. Your lawyer will do that. All that.
My lord.
You only have to adduce evidence.
My lord.
You have to file an affidavit and to be cross-examined. That's all. Further, upon 205 already allowed each. Nothing further has to be done by you. The petitioner.
If the petitioner will move to Bhavanipatna, there will be threat, my lord.
What threat?
The appeal number 1 is in a move to
So you
their henchmen to attack me.
don't you approach the police, you can approach the court.
I have already approached to the Bhavanipatna police. But
Where is that affair? Where is that affair?
kind of that fair copy has not been.
No. There is no ground for transfer. The petitioner.
Your Lordship, may kindly observe. I will conduct the case on virtual.
No. Conducting the case virtually.
My lawyer will conduct the case on virtually, Lordship.
Well, your lawyer will conduct it virtually. Why? I can permit you as a party to appear virtually if necessary. Why will your lawyer? And more so when you have been exempted from personal attendance. 205 has been allowed.
Yes, my lord.
So if 205 has been allowed, there is nothing against. Anyway, the petitioner seeks transfer, who is an accused in 1cc case number 3 of 2023, pending in the court of learned SDGM Bhavanipatna, seeks transfer of the said case to any other court outside Bhavanipatna. Prayer for transfer has been made on the ground that the petitioner apprehends danger to his life if he travels to Bhavanipatna, as the the complainant opposite party and his hooligans and his friends and his associates may cause him harm. Stop. This court does not accept the above as a valid ground for transfer, for the reason that in case the petitioner apprehends any danger to his life, it is always open to him to approach the police or even seek protection from the court. That apart, in course of hearing, 11 counsel to the petitioner submits that the petitioner has been exempted from personally attending the court as per the court as per section 205 of CRPC. Under such circumstances, I find no reason to grant the prayer made by the petitioner. Stop. The transfer application is therefore dismissed.
No,
It shall be open to the petitioner to seek permission of the court to appear virtually if he so desires. Next. Already the personal attendance exempted each. All right. Yes.
If you look complaint before the local police will
No. That direction cannot be given. It shall also be open to the petitioner to move the police authorities seeking protection if he feels threatened by any person. Yes.
Item 3.
Item 3.
Item number 3, it is a transfer petition, and the petitioner is the father-in-law of the opposite party.
Yes.
And he is a very old person and 67 years old, and medical issues also there. And the opposite party has initiated a DP case in the Panpos, SDGM court Panpos. Interestingly, my lord, all 3 proceedings by the opposite party is now conducted at Bhubaneswar. And the son of the petitioner have filed a divorce case in Raulkela, and the opposite party moved this honorable court and gave the transfer petition to the Bhubaneswar. And now she has filed a DB case in Raulkela. It is a hardship for me to attend there in Raulkela. It is 500 kilometers from here, from Bhubaneswar.
All right, take notice, issue notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow peremptorily. List this matter on
16th July.
16th July. In the meantime, if any application for adjournment is moved by the petitioner in the court below, the same shall be considered, having regard to the date fixed for hearing of this case. Yes.
Item number 4.
Arrangement.
The husband is before your lordship.
Yes.
My lord, initially the husband filed a petition for divorce. The wife, after getting the notice, filed a 125 proceeding before the judge family court Sambalpur. Challenging that divorce notice, the wife has already filed a TRPC and your lordship has stayed the proceeding before the judge family court Kendrapada, fixing on 12th. My lord, this matter may be posted to 12th. I'll file, your lordship may permit, I'll file an adjournment. So both the matters your lordship can decide, because one by the husband for divorce filed in Kendrapada, where they is seeking a transfer to Sambalpur. She is a resident of Kendrapada.
See, AP Bose Learned Counsel for the petitioner submits that the opposite party wife has filed a transfer application.
TRPC number 76 of 24.
Being TRPC number 76 of 2024, seeking transfer of the divorce case filed by the petitioner husband before
Judge Family Court Kendrapada.
Judge Family Court Kendrapada, which is posted to 12th of this month, 12th of July. Yeah. Stop. He therefore submits that both the cases may be heard together for a just decision. Stop. In such view of the matter, list this case on 12th July along with TRPC number 76 of 2024. Stop. But in the meantime, if any application for adjournment is moved by the petitioner in the court below, the same shall be considered, having regard to the date fixed for hearing of this case.
Well, should I take notice to the wife so that she can?
All right, you take notice. All right, that also. Taken together. Issue notice to the opposite party by speed post. Requisites for which speed post fixing a short returnable, fixing a returnable date before 12th July. Hello. Requisites be filed by
Speed post.
it will be filed in course of the day. Peremptorily.
Tomorrow your lordship may say I'll file. Tally file.
By tomorrow peremptorily. Hello. Let's just matter along with such and such on Juzale Khaicho. Yes.
Great.
Item number 5.
Item number 5, my lordship. On earlier occasion, pursuant to the direction issued by the Honorable Court, lordship has instructed me to take instruction so far as appearance of the wife before the cancellation proceeding.
Yes.
Both have not appeared.
Both have not
appeared before the consulate because the date was not given to them. That's how no notices were issued, no date was given.
See, Mr. Learned Counsel for the petitioner submits on instructions from his client that neither party appeared before the conciliator as no notice was issued for conciliation proceeding. So, what is this you want to transfer from?
My lord, the petitioner being the wife, my lord, seeks transfer of the mat case filed by the husband from the file of civil judge, seniority judge Rajgangpur to the learned judge family court Kendrapada.
All right, issue notice to the opposite party. by speed post, fixing a short returnable date, requisites be filed by tomorrow positively, peremptorily. Place this matter on 16 July. IA adjournment.
Well, the husband is also appearing in a criminal proceeding at Kendrapada, 120.
Item number 6. May I plead the my lord, the wife with the petitioner here on the opposite party now is the husband. The petitioner, my lord, seeking transfer of the CP case, my lord, from the district of Rayagada to the Court of Law and Judge, Family Court, Gajpati at Paralakshmi.
Right.
1 year breastfeeding child is there, my lord, and a district.
Issue notice. Date speed post, huh?
My lord, 16 July.
16 July.
Tomorrow I will file.
And adjournment.
My lord.
Yes.
IA. Item number 7.
Is a transfer application mirror from Barampur family judge to Bhubaneswar. Actually, what has happened, Miller, my suggestion is the petitioner is a doctor.
Petitioner is a
doctor. He is a husband. Miller. Opposite party wife also a assistant professor in a engineering college. He has filed a divorce case at Barampur, and petitioner has filed a divorce case at Bhubaneswar, Miller. So, what I suggest, Miller, if it go to mediation center, both that means both want divorce, Miller, since they have both have filed two divorce cases. If it will go to the mediation center, I hope that can be. And so, your lordship.
No, what is the ground for transfer, Mr. Rafa?
Transfer, Mr. J. Doctor in some hospital, in a busy when your lordship a physician is always busy with the patients, Miller. It's difficult for him to go and conduct the cases.
So if it is transferred again, the wife will face the same problem.
That I understand.
Wife will also face the problem. Wife is a doctor.
That I understand. Now, wife is a assistant professor in engineering college.
Anyway, she is a teacher.
She is a teacher.
She will also face problem.
Yes, yes.
So convenience of the wife is to be taken.
Yes.
That is that will be given more preference.
That I understand.
And you can also appear virtually if you want. If there is a specific instruction or if there is any specific, definite possibility of mediation, yes, the court can consider. But
I can let.
Now, simply speculation Mr.
No, I don't speculate, Miller.
Can we speculate that asile kale settlement
No, because both have filed the divorce case. I understand that will be amicably settled, Miller.
No, but the question is, all right. Issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed by tomorrow peremptorily. List this matter on
16th July.
16 July. Adjournment. That adjournment order will be passed out. No stay.
Item number 8.
May it please your lordship. Before I address your lordship, your lordship may kindly recollect on the last occasion this matter has been listed, and your lordship expressed some doubt regarding the maintainability of this particular.
This matter was listed before.
Yes, madam. And I may be permitted to address on that point regarding the maintainability.
What is the matter? Let us see.
Yes, madam. Your lordship expressed certain doubts regarding the maintainability of this writ application. May I be permitted?
No, yes, please tell me what is the matter.
Yes, madam. The background of this case is, my lord, petitioner in his representative capacity as president of a registered society Kui Samas has filed this writ application. In the year 2003, Government of Orissa in the Education Department had issued a circular that for upliftment of the downtrodden branch of the society, including SC and ST candidate, specifically the petitioner represent the Kui branch of ST for getting upliftment in the society, so that for the advertisement for the filling of the vacant post of Shikha Sahayaka, they require trained graduates, madam. There are certain reserved posts, there are certain unreserved posts. There is a circular in 2003 by Government of Odisha that if the reserved and unreserved posts are not filled up, qualified person, trained graduates are not available, then that can be filled up by ST candidates for unreserved category. If that is also not filled up, then untrained graduates of ST community can fill up the vacancy of unreserved post. That was 2003 circular. Accordingly, another 2006, a merit list was published. Around 10 to 15 of these QI members were selected therein. Unfortunately, few of them in their individual capacity moved this honorable court as many as 11 occasions. They didn't get any redressal, they got only a dismissal. No adverse order, but only dismissal. Their applications are not been accepted. So that is, I am concerned that is a matter of 2006. In the meantime, from 2006 till now, there are 11 writ applications. They won't get any success. Therefore, these writ applications are filed for those candidates having 2-4 prayer, my lord. First prayer is, I am conscious that this is 2006 merit list, my post is there, but up to 2016, from there, that 2006 merit list in other districts, on trained ST candidates have been appointed. Those annexes I have filed, I have obtained application and filed annex those documents that they have been appointed, but I have been discriminated of my society members have been discriminated. My prayer is twofold, my lord. I am concerned that that is 2006 matter. In the meantime, 18 years have passed. They must have got higher up in their age. But if there are certain vacancy and government really desires that for uplift from that society, some of those eligible persons, those who are found placed in the merit list, because up to 6 to 16 we have made appointments. So further those appointments can be made. Or on the alternative prayer also made, my lord, like 2003 circular, some fresh circular may be issued, so that these qualified persons and below qualified persons can get an opportunity. That is my alternate prayer also in this application. And the main prayer is, since 2016 we have made appointment of 2006 merit list. You can also, if there are certain vacancies in further advertisements, they may be adjusted. And regarding how the petitioner can represent the QI people, I have a decision of this honorable court.
What is the ratio?
That is that for a policy decision, the teachers' cost can be raised by their association, board of secondary education society. That can be.
So, and who are you?
I am the president of the QI Samaj, Ratio Society.
So, how do you know that they are members of that QI Samaj Seva Samiti? This is acting in for the upliftment or the welfare of the QI people.
My society.
Yes.
Yes, sir.
Yeah, QI people at large.
At large, right.
But there, those teachers, they form part of a particular association. So association moved on their behalf.
Right, right.
Here, this is not. It cannot be.
All the QI persons are.
All the QI persons in the world will be. How come? So this is a class action suit. I had told last time. So you have to be a person aggrieved in order to maintain this writ application. So how are you a person aggrieved? QI Samaj? Yes, there are not 1 or 2 persons. QI Samaj is at large.
I understand the bottleneck, my lord.
That is one. Second part is you yourself said that you had already earlier approached, some of the individual candidates had approached. So will it not act as a res judicata, even otherwise? If that is, you have not gotten relief. Rather, what I would suggest is, without making any further submission, you may seek withdrawal with liberty to move the. That would be better. What do you say? Huh?
Yes.
I think that would be an course order.
Yes. Will your lordship kindly look?
I will. If you want, yes, I will.
So page 3, para 3.
Orissa Secondary School Teachers Association.
Yes, ma'am.
So all those who are secondary teachers.
I understand.
For them.
Ratio decided here is, my lord. Since the society, how the society can represent its members.
There is no dispute.
This is requirement because I was also involved with this Orissa Secondary School Teacher Association for last 30 years. All that requires you must be a teacher somewhere. But in QI Samaj, my submission is all that is required that you must be a QI. Not that you have to be registered yourself a registered member.
Yes, the QI Seva Samaj may take up the causes of QI people everywhere.
Yes, ma'am.
But to maintain a rate application as these secondary school teachers have done, that will be a different. So I think there's a distinguishing feature.
Regarding,
But let me tell you one thing. You see, all those persons who are members of this Odisha Secondary School Teachers Association can be represented by this association. But all the quiz in general cannot be represented by them in a particular action. That is the distinction. So what I would suggest rather, no.
Yes, ma'am.
Yeah.
Then my submission is, my lord,
ଆପଣ ସିଧା
another 6 representation is pending.
that is what I am saying. No, I will rather I will permit you to file a fresh representation.
Yes, ma'am.
That will be better. You file a fresh representation. Simple.
Now, you also understand my problem, my difficulty, my lord. I couldn't place the grievances of my people who are suffering to show that to get a redressal. That's what I want ventilating before a lot.
No. It's not that. There are two technical
Right, man. Right, man.
legal bar. Legal bars. I'll tell you how. First is that res judicata thing will stare at you. Second is time bar 2006. Third is maintainability, locus standi.
Right, man. But up to 16, they have made appointment from 2006 merit list.
I'll simply
They can extend it for all.
without observing anything, I'll simply permit you to withdraw.
Right.
If I make any observation, it may go against you or something.
I understand.
In course of hearing, learned counsel for the petitioner seeks permission to withdraw the writ application with liberty to move the commissioner cum secretary to government in school and mass education department. Move the to seeking redressal of the grievance, seeking redressal of his grievance as laid in the writ application. Stop. Permission is granted with liberty as aforesaid. It is further observed that if any representation is submitted by the petitioner within 2 weeks from today, the commissioner cum secretary shall consider and dispose of the same in accordance with law within a further period of 4 weeks. 4 weeks. Yes.
No, 9. I'm sorry, my lord, I have got a very bad case, but I'm happy that you also understood my problem.
May I, lord?
Yes.
Sir, ओडिया कौच
कुहतु
सर 2016 रे जो शिक्षा सहायक बार थिला माइलर तो सेथे म अप्लाई करथिले कलाहांडी डिस्ट्रिक्ट एवं एट दैट टाइम आई एम एलिजिबल किंतु एमाने कोन कले दुईटा प्रिफरेंस देके बंद कर देले एपर के कलाहांडी रे 7टा एससीबीसी पोस्ट मो कैटेगरी रो बळी गला पर मु मान्यवर कोर्ट को जाइथिली एवं 9325 बाय 2023 रे मु गोटे डब्ल्यूपीसी फाइल करथिली एवं सेथरे रिप्रेजेंटेशन दिया हैथिला एवं 3 मास टाइम दिया हैथिला एवं 3 मास भितर से मानको कंप्लाई करिया को हैथिला 3 मास गला पर से माने कंप्लाई कलेनी मु फास्ट कंटेम्प्ट गली फास्ट कंटेम्प्ट रे किछि कलेनी सेकंड कंटेम्प्ट ता पेंडिंग अछि जोटा मु पूरा मेंशन करछि मो ए प्रेजेंट रिट डब्ल्यूपीसी रे एवं एबे मीन टाइम कोन करछिंदी गवर्नमेंट 20000 अपॉइंट कर देबो जूनियर टीचर तो मु आउ किसी असुविधा हो बोली कि आय फाइल गोटे करी बोली भाबिली तो कोथरे आय फाइल करबी से तो कंटेम्प्ट रे तो आय फाइल हबनी तो आ गोटे माइलर आपन पाखे मु सेति पे आसी एवं रिसेंट आपन को कोर्ट रे ममता नायक केस रे एग्जिस्टिंग वैकेंसी रे अलाउ करा होइछ ताको डायरेक्शन दिया है कि मु अनेक्स 4 रे देछि माइल रीड कॉपी गोटे कॉपी रे से
रीड पिटिशन कॉपी देना
हां मु देछि तो कॉपी देछि माइल हां देछि अब बिहाइंड देछि किछि प्रोपोजल देछि
Didn't copy it?
Receipt
So that 30 district, that thing. Here you, preference. The same, that 5.5, 5.4, those things. That is this is the case which I was referring to. Yesterday somebody was moving, I told him that refer to this case. Yeah, kali kiye.
asada kali rakha
You keep note of this case. So I think
Annexure 4 ରେ ଦେଇଛି ମମତା ନାୟକର ଅର୍ଡରଟା
ତାକୁ ଆପଣ ଆପଣଙ୍କୁ କପି ଆଉ ଗୋଟେ ଦିଅନ୍ତୁ,
ଗୋଟେ କପି ଦେଇଦେବେ।
ଗୋଟେ କପି ଦିଅନ୍ତୁ,
ଆଜ୍ଞା।
କପି ଦିଅନ୍ତୁ, take it up tomorrow. ହଁ? ସେଟା ହେଲା WPC number 10791
ହଁ ଆଜ୍ଞା
10791 of 2022. The petitioner Jitendra Kumar Sahu appears in person. He is directed to serve a copy of the writ application on the State Council in course of the day. Place this matter tomorrow. See, the will dispose of. Yes. Whether it is covered by this case or not, you just examine. As it is देखिए.
ସାର୍ ମୁଁ ପୁରା କଭର ଏଲିଜିବଲ ଥିଲି
ସେଟା ଆମେ ଡିସାଇଡ୍ କରିବା, ଆପଣ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ।
ଆଜ୍ଞା
ସେଟା ଆପଣ ଡିସାଇଡ୍ କରନ୍ତୁ, ଆପଣ କପିଟା ଦିଅନ୍ତୁ।
ହଁ ମୁଁ କପି ଦେଇଦେବି
ଦିଅନ୍ତୁ, ଆଜି ଦିଅନ୍ତୁ।
ଏଇଟା ଦେଇଦେବି
Yes.
ହଁ ମୁଁ ଦେଇଦେବି ଏଇଟା ମୁଁ ଲୁକିଂ କରିଥିଲି ଏଇଠି ଦେଇଥିଲି
ଛାଡ଼ନ୍ତୁ, ଯାଆନ୍ତୁ। ଯାଆନ୍ତୁ ଆଜ୍ଞା, ସେ ଜାଗାରେ ଛାଡ଼ନ୍ତୁ। ଆପଣ କେସ୍ ସରିଲାଣି, ଅନ୍ୟ ଓକିଲ ଠିଆ ହେଇଛନ୍ତି।
taken along with the WPC number of 14,255, the extradited 2 cases are there for inclusion of the
এই ଯୋଉ GPF ଆଉ old pension rule ରେ ଅଙ୍ଗନବାଡି
next week ଆପଣ ରଖିଛନ୍ତି ସେଇଟା।
next week କୁ ରଖା ହେଇଛି।
ଆଚ୍ଛା, ଏଇଟା ବି ସେଠିକି ଯିବ, ଦେଖୁ ଯାଇଛି।
ସେଇଟା ହଉଛି
ଗତକାଲିର next week।
ଗତକାଲି ମାନେ ସୋମବାର ହେଇଥିବ ନାଇଁ? Let's just matter next week. ମାନେ next week ତ ନୁହେଁ, on 24 କେବେ ଏଟା 1 ଜୁଲାଇ along with ଦରକାର ନାହିଁ, ଏକାଠି ଥିବ, ଲିଷ୍ଟ ଆସିଲେ ଦେଇଥାନ୍ତି, ଏକାଠି ନବ।
ଆଉ ଗୋଟେ ସିମିଲାର ମ୍ୟାଟର ଆଉ ଗୋଟେ ଅଛି।
Yes.
Item number 11. May I please your lordship. So second round litigation matter.
Yes.
The petitioner was appointed as Anganwadi worker. As per the revised guideline, the date of expiration is 60 years.
Yes.
In 2019, government issued fresh guideline, revised guideline, wherein the age has been enhanced by 2 years, my lords, subject to fulfilling of certain conditions.
52 60 ହେଲା ପରା?
62 ହେଲା.
62 ଆଚ୍ଛା, ହଁ
62.
So
my lords, just before 2 months before my retirement, I submitted my willingness under annexure 3, my lord.
yes.
And that was forwarded to the sub-collector by the CDPO lately, my lords.
Yes.
And when the collector did not accord approval, I approach your lordship. Your lordship directed the authority to examine the case and pass appropriate order. No order has been issued to me, but when I approached the DSW, he handed over letter of the sub-collector under annexure 6. Under annexure 6, wherein my application has been rejected on the ground that delay submission of the application. And that in that respect, I would like to submit my delay in forwarding the application is not a ground to reject my application. And that 3/2000
you take notice.
Yes.
Earlier your lordship protected me to interim order.
Sri S.N. Patnaik, learned AG.
Our submission, my lord, it has been submitted even after 2 years, 2 months.
ଦେଖିଦେବା କାରଣ last writ application there was a direction.
Yes.
That you have to consider the proposal.
Yes.
So he has raised certain issues of delayed forwarding and all that. Let us examine it.
Well, the document what he has submitted, that is the document.
No, annexure 6.
That is the rejection.
If that rejection was never intimated to her, then
annexure issued the notice, my lord. I do not have any notice to that one. Only my submission, my lord. The ground of rejection is that, my lord, that she didn't submit the application within the prescribed time as it has been stipulated. And the document which she is relying upon, that is a document beyond that particular period of 2 months. So how she can submit an application prior to that 2 months, my lord?
you obtain instruction and
retirement ମୁଁ 4 agree just ଯଦି ହଇতো ଗୋଟେ ଦିନ ଏପଟ ସେପଟ ହେଇପାରେ, କିନ୍ତୁ ସେମାନଙ୍କ ଫରୱାର୍ଡ annexure 4 ସେମାନେ ମାନେ ସବମିଟ କଲା, ପୁଣି ରିସବମିଟ 19/3 ରେ ସେ କହିଲା 19/3 ମୁଁ କୋଠି ସବମିଟ କରିଛି. It is not my fault.
Learned Sri S.N. Patnaik, learned AG shall obtain instructions with regard to the amendments made in the writ application. Let's this matter mu 10 दिन time देंगे.
Yes.
10 दिन में खाली just on instruction, no counter is required.
Yes.
Release this matter on
9th July.
9 July. Till such time, you have been disengaged.
No, I haven't continued because earlier order was there, my lord. Your also protected me. To page 27. To continue the other decisions allowed till such a decision taken by the
Till
sub-collector.
such time, the petitioner shall be allowed to continue as Anganwadi worker of Mundra Guda Anganwadi Center. Yeah, that's all. Yes.
Internal 12.
Please, your lordship, Lord, this matter relates to NGO matter, my lords.
Relates to
NGO matter.
which one? NGO में?
NGO matter, my lord.
NGO matter में जानने को.
It ought to have been listed before Honorable Justice S.K. Panigrai, but wrongly listed.
This is a matter relating to NGO non-government organizations, my lord.
Correct.
And it was blacklisted.
Release
So
this matter
his
before
grievance
the-
is that matter, it is wrong.
Release this matter before the assigned bench.
Item number 13.
I have OP number 5 on behalf of Chris.
Last order.
2007 matter, selection of Asha Karmi. There was no unanimity, so lottery system was adopted.
Yes.
That is our counter.
Just briefly let us recapitulate briefly what are
My lord, your lordship kindly see page 5 of
Pathal matter. Prior to vacation,
oh,
last time you had not appeared.
no,
That is why it was added on. Yes.
additional affidavit, page 5.
No, what is your, just tell me the facts, I will remember.
Selection of Asha of opposite party number 5 as Asha is under challenge. So for her qualifying academic purpose or age is not there. She was selected behind back the selection committee. That is my sole ground.
What steps have you taken?
No, in fact, there ought to be unanimity in the selection of the Asha Karmi.
But what about lottery?
Lottery, because there was no unanimity, so lottery system was adopted. That is the counter plea.
Is there any such a provision for selecting candidates by lottery?
That I have not checked out. But
That is
Because in lottery, whenever there is a lottery, there is an element of arbitrariness,
maybe.
isn't it?
Yes.
Then public employment, how can there be an arbitrary decision?
That is our stand.
What is this additional affidavit?
additional affidavit. I have given that your lordship kindly turn to at page 5. This is documents obtained under RTI.
Yes.
Got it, my lord? Serial number 6,
Pratima Sethi.
my lord. Opposite part number 5. Age is 22, whereas guideline says must be above 25. Next, your lordship kindly turn to next page. 6.
Yes.
Last but one paragraph. समस्त आशा चयनर मेंबर मानक विचार रे आशा चयनर निष्पत्ति होई न पारी आशा चयन प्रार्थी आड़ू गंडगोलर समस्या देखागला या परे ग्रामर स्वयं सहायक गोष्ठी द्वारा धर्मगोला पकाइबार निष्पत्ति नियागला एवं धर्मगोला पकाइला परे प्रतिमा सेठी नाम बाहरला. लॉर्डशिप काइंडली टर्न टू नेक्स्ट पेज. Page 7. This is also under RTI I obtained. अद्य 18/12/2006 टिके पढ़ी होनी थर्ड
रामकृष्ण बेहरा को सभापतित्व रे आशा चयन पई
नहीं नाटा अछि प्रतिमा सेठी एज 27
उक्त सभारे निम्नलिखित सभ्य मान उपस्थित रही परिशेष प्रतिमा सेठी स्वामी इत्यादि इत्यादि योग्यता
अष्टम पास सर्वसम्मति
27 बयस 27 लिखाई
आज्ञा से 27 आणले कोठ अष्टम पास आणले कोठ से तो 2008 मसिया रे ट्रांसफर सर्टिफिकेट टा पाइला सेटा भी भूल फेक सर्टिफिकेट नहीं मु एठी खाली कहबा चाहूची जे सर्वसम्मति क्रमे आशा पदवी रे चयन हला फिर धर्मगुला कोन ପୂର୍ବ RTI ଡକୁମେଣ୍ଟରେ କହିଲେ ଧର୍ମଗୁଳା, ଏଠି କହିଲେ ସର୍ବସମ୍ମତି କ୍ରମେ ତାକୁ ବଛା ଯାଇଛି। ସର୍ବସମ୍ମତି କାରଣ ଇନ୍ ପ୍ରେଜେନ୍ସ ଅଫ୍ ଅଲ୍। ଏଠି ଆଉ ଗୋଟେ ଡକୁମେଣ୍ଟ ଦେଇଛି, ସେଥିରେ ଡକୁମେଣ୍ଟଟା ଯୋଉ ଅଷ୍ଟମ ପାସ୍ ସାର୍ଟିଫିକେଟଟା ସେଟା ଟିକେ ଆଜ୍ଞା ମୋର ରିଜେଣ୍ଡର ଆଫିଡେଭିଟରେ ରିଜେଣ୍ଡର ଆଫିଡେଭିଟ ପେଜ 9 ଲର୍ଡସିପ କୋର୍ଟ
Yes.
ଗୋଟେ ଲେଫ୍ଟ ସାଇଡ ରେ ଟପ ରେ ଅଛି ଫୋଲିଓ ନମ୍ବର 10/125710 same folio number has been issued 2007. Lordship turn to next page. That was issued to Sweta Paikara. And I have obtained 2007 some certificates, 2008 some certificates, that is increasing, but in between this is coming the same folio number. And this was obtained by her 9 to 2008, whereas examination selection is 2006, December 2006. How they got it? They came to know that she has completed 8th, because that is 8th is minimum qualification. And how that was considered?
All right. Yes.
I'm on behalf of Kuresh Vasadas. I don't know what is that.
Yes.
I don't know what is the case, man.
What kind of submission you are making?
He is appearing on behalf of
That I can understand. That I can understand. All right. Hearing concluded. Judgment is out.
Wanted time for
Parties may file their written. Parties may file their note of submissions and memo of citations if any within a week.
ଖାଲି ଆଉ ଗୋଟିଏ ପଦ କରିବେ, ଦୁଇ ଜଣଙ୍କ ନାଁଟା ପ୍ରପୋଜ କରାହେଇଥିଲା, ସ୍ୱୟଂ ସହାୟକ ଗୋଷ୍ଠୀ ପ୍ରପୋଜ କରିବେ, ପ୍ରକୃତରେ ମୋ ନାଁ ପ୍ରପୋଜ କରାହେଇଥିଲା, ବିହାଇଣ୍ଡ ବ୍ୟାକ୍ ସି ୱାଜ ସିଲେକ୍ଟେଡ, ଯଦି ତାର ସିଲେକ୍ସନ ଟା ଯାଉଛି ମତେ ସେମାନେ ସିଲେକ୍ଟ କର, ଦ୍ୟାଟ ଇଜ ମାଇ ପ୍ରେୟାର।
ଦେଖିଆ
ନୋଟ ଅଫ ଆର୍ଗୁମେଣ୍ଟ ନୋଟ ଅଫ ଆର୍ଗୁମେଣ୍ଟ କେବେ ଯାଉ?
within a week. I don't know 14. Pass over. All right, pass over. I don't know 15.
At least nuts. Will recollect that.
I may kindly pardon my lord. On behalf of opposite party number 3 for BPUT, I may kindly be permitted to place the matter on behalf of my senior Mr. Nirmalanjan Rautri. Actually,
Good. You are supposed to file an application for amendment.
Yes, my lord.
Have you filed?
No, I'm filing an affidavit because it is doubtful whether it is a deemed university. Because the stand they took was that it is now deemed university and beyond their control. So I verified, and whatever upfront information I found, it is not a deemed university. And so I'm filing an affidavit. I've applied under the RTI Act to confirm, because they have filed an affidavit asserting that it is a deemed university without any material in support. So but now my learned friend says that she has instruction that affidavit is
only a short correction about the counter which filed by R3, that is BPUT, that is a short typographical error.
Yeah, that is all right. That you can correct.
That
what is that typographical error?
Now university within bracket para 2 of my counter. Now university that may kindly be ignored, my lord. My sincere request.
No, you score it off. You make your necessary correction. Then counsel applying for the opposite party number 3.
Yes, my lord, BPUT.
Opposite party number 3, BPUT. Submits that there's a typographical error in paragraph kete?
Paragraph 2 of my counter, 12 line college after
Paragraph 2 of the counter affidavit. Counter affidavit. And that
that one may
and that
kindly
needs to
ignore.
be corrected. Stop. Good. Let him correct it. The counsel for opposite party number 3 is permitted to make necessary corrections in the counter affidavit in court.
There is a consequential correction also they may have to do, that is, they have stated that it is outside their control. So obviously now that last line.
Allen counsel for the petitioner, you are filing an affidavit or you will file an affidavit?
No, I have the affidavit ready, but now they have
get the information through the RTI, then file. Why are you doing it now?
I just
Allen counsel for the petitioner submits that as per instructions received by him, the institute in question is not a deemed university. He has applied for information in this regard under the RTI Act and requests for an adjournment in order to make necessary submissions. Let's just matter 2 weeks, 3 weeks,
3 weeks.
Huh?
16th July.
16th July.
3 weeks.
16th July, yes.
Obliged.
Much obliged.
Item note 16.
Monthly yours. This is a case, my lord, matter relating to the engagement of Sikha Asaka 2006, my lord. Last occasion, my lord, and your lordship's last sitting, my lord, your lordship directed to the government council, my lord, to file the additional counter affidavit. The additional counter affidavit has been filed, my lord, but the reply to that has not been filed. So, your lordship fix a short date, my lord. Or
Circumstances are also obtained instruction as to why the petitioner's engagement as Sikha Asaka shall not relate back to the date on which the Board of Secondary Education issued notification declaring equivalence of BSc course with CT. Yes.
That instruction I have not got.
That was in February 2023. 21/2/2000. Yes, 21/2/2023. When I was in my last assignment. 1 ବର୍ଷ 4 ମାସ। କଣ କରିବା?
The counter ଦେଇଛନ୍ତି ତାପରେ February the counter ଦେଇଛନ୍ତି.
This is the last order.
My lord, that is the last order. Thereafter they filed a counter, additional counter appeal.
Additional counter they may have filed.
Lordship may pass it over.
All right, pass over.
Lordship fix it to.
ନା କରିବା pass over ସେ ଦେଖିଦିଅନ୍ତୁ ତାପରେ adjourn କରିଦବା।
Item note 17. My lord, this matter relating to the additional session teacher matters. Counter and the regional, everything has been filed. So I feel also can be taken out next week because of Mr. Price.
Therefore, adjournment is made on behalf of Mr. Swai. As he has bereavement in the family, let's this matter next week.
Item number 18.
To file regional reports time में कर लिया।
My lord, with great respect, my lord,
Let me see.
kindly see the order sheet.
Let me see. The same prayer you had made 2 years ago. 17/11/2022 भी कहते regional file करिए होगी. So you actually you don't intend to begin.
मतलब पहले possible
No passover.
But
Please begin.
last chance 2 weeks time.
No. I said no. Prepare. Yes.
But I am for the OP number 5. Your lordship may kindly see.
You are for the opposite but number 5. Yes.
At my behest.
What is the matter? Let the petitioner place the matter. ADM in revenue miss appeal number 15 of 15. What is this matter?
My lord, on the basis of practicing fraud and false certificates, false date of birth, she has been appointed as Anganwadi worker. I filed an appeal before the Lalin.
No, but the prayer may not be maintainable here. Look at the prayer. What is your prayer? By the learned ADM Balangir revenue miss appeal number 15 of 15. So this probably relates to
Anganwadi appeal, my lord. That is a nomenclature set time so revenue miss appeal kar dothile.
Oh.
It's an Anganwadi appeal.
I thought this was
My lord. Anganwadi appeal, Lalin ADM has set aside her appointment because she has filed false certificates. And in my, if your lordship may kindly see the impugned order under annexure 5.
No. Yes. Don't just
kindly pass over.
All right, pass over.
Item 19.
My lordship, on behalf of the petitioner, this is a matter where we are challenging the a fresh advertisement issued for engagement of Shiksha Sahayaka, which has been advertised without exhausting the list previously prepared.
Just a minute.
Uh,
Just a moment. You have to take instructions again, February 2023 matter. And I have also passed an order on the next date. Next date means in the
7/5.
yes, 7/5/2024 that the previous order has to be complied with. And the Chief Secretary himself very recently appeared before the Chief Justice and said that we have a very robust litigation policy and we are going to comply with all the orders passed by this court.
They have been complied.
The lordship granted time to comply the order, but till date they have not.
It have been complied. Your lordship may let me ascertain if they have complied in the meantime. Specific instruction was given.
Yes.
Tomorrow, your lordship may call it.
All right. As requested by Learned AG, list is matter tomorrow.
Item 21.
Item number 21 is Srinivas physically handicapped petitioner in person. Sir, my dates are actually 21 March.
The previous order. Law Department had tendered a favorable opinion and you were required to obtain the file from the Law Department. The last time you said that it could not be instantly traced.
Okay. In fact, an instruction has been issued.
Yes.
That during the year 2006, there are 16 vacancies for the post of Shiksha Sahayak in Cuttack district, out of which 11 and 5 posts were reserved for scheduled CT and B.Ed qualified persons respectively. Out of the above 16 posts, 1 post was reserved for physically handicapped category, and the petitioner Sri CORAM was placed at serial number 2 of the physical handicap category. As such, he was not engaged in the year 2006.
So who was engaged?
The other person, that of course the name has not been given.
File an affidavit. This instruction be submitted by way of an affidavit.
And giving the person who has been given.
Yes, so that he can reply if at all.
Yes.
They say that there were 16 vacancies. Kadiru Gotiye physically handicapped kota pai reserve thila. You were placed at serial number 2 in that list, physically handicapped. So there were another physically handicapped person securing more marks than you. Naturally, there was 1 post, so he got selected. This is what they are saying. What is your preliminary reply? ଦୁଇଟି ପୋଷ୍ଟରୁ ଗୋଟିଏ ପୋଷ୍ଟରୁ 2 ଜଣ ଥିଲେ ମାନେ ଫିଜିକାଲି ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ କ୍ୟାଣ୍ଡିଡେଟ୍, ଜଣେ ଆପଣ ଆଉ ଜଣେ। ସେ ଆଉ ଜଣକ ଆପଣ ଗୋଟେ ଅଧିକା ମାର୍କ ରଖିଥିବା ହେତୁ
Sir, serial number 1 ଥିଲା।
ସେ ପାଇଗଲେ।
Sir, serial number 1 in the selection list did not turn up for appointment.
ତେଣୁ ଆପଏଣ୍ଟମେଣ୍ଟ ହେଇନାହାନ୍ତି।
Did not turn up for appointment se participate କଲାନି।
କଲେ।
Sir, accordingly, I was entitled to 1 post. Reserved for the visually handicapped. So 1 post was specifically reserved for the visually handicapped.
All right, again.
Person with low vision.
ଆଜ୍ଞା ଟିକେ ରୁହନ୍ତୁ। 3 ଥର କହିଲେ ଟିକେ ଅଲ୍ ଟିକେ ରୁହନ୍ତୁ ବୋଲି। ଶ୍ରୀ Yadav Leonard AGA has obtained instructions that there were କେତେଟା vacancy?
2 vacancies, 1 vacancy for physically handicapped.
No, total vacancies
Total vacancies were 16.
That there were 16 vacancies at the relevant time, out of which 1 was reserved for physically handicapped candidates.
Yes.
The petitioner was the second physically handicapped candidate and therefore was not given engagement.
Could not be given.
Could not be given engagement. Sri Srinivas Kaur, learned counsel, the petitioner appearing in person, submits that the first candidate selected for engagement under the PH category never joined, and therefore he ought to have been considered for engagement. The State Council shall file an affidavit in this regard. Place this matter next week. Next week as well, say good affidavit file kare apan dekhibe file an affidavit in this regard. Place this matter next week.
Item 22.
Procedural part. Item 20. In that contempt, you have received that compliance.
Affidavit.
Yes. No,
But
affidavit will be filing.
already you file an affidavit ko kali bhitar apan file kar diyo.
Already a copy of the same has been sought upon the council for the petition.
Affidavit diya hoichi?
No, ଆମେ ତାକୁ ଦେଇଦେଲୁ କପିଟା ଅର୍ଡର କପିଟା ଦେଇଦେଲୁ।
Acha. So we'll take it up. Yes, what do you say? You have seen it?
No, without I'm received, madam.
तो काली आसु देखि देबो काली जाय सेही बेसिस रे ड्रॉप कर देबो आ एफिडेविट कोन
Item 22.
हम लोग मेमो करके फाइल कर दे परिबे आइटम 22 yes
Okay, my lord, this is a transfer of matrimonial suit from Bargarh to Patnagarh.
yes
As per my lord,
notice
I have already notice has been served twice.
हां कोन है नोटिस चे देखले
आगे से already दिया है बाबू से मते फोन करथिले आईएससी और फोन करथिले the person is not available at how and the other family members are not receiving the copy. Do you intimate the court? Intimate what has you intimate?
Yes.
वर्ष लाने गटे फाइल कर से अपील करने किछ करना थी
कोन करे दुखर कथा रे कोन करे yes
ट्रांसफर जब दिथर नोटिस लाने से
what is your instruction from the IAC
sir देई ना दी मो आज पहुंचल काली के
oh let's this matter tomorrow
tomorrow next week tomorrow kali achi china matter achi
oh this matter next week Leonard the State Council shall inform the court regarding service of notice
next week is our date
statement next week man next Tuesday
next Tuesday item 23 my lord
item 23
the petitioner has challenged the order dated 8/6/2022 of disengagement of the Hon'Ble worker. As per the last order, we had filed an affidavit that we are continuing.
no you were on worker you were disengaged
I was continuing since 2010, my lord. By the annexure 2,
disengagement hele pura appeal ଅଛି
appeal टा परे ଆମେ ଆସୁଛୁ ଏଠି
appeal order ଟା ନାହିଁ
ସେଇଟା ହଉଛି annexure 1.
oh annexure 1 ସେଟା ଆଚ୍ଛା ସେଇଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
my lord.
ଆଉ କି ଆପଏଣ୍ଟେଡ ହେଇଛନ୍ତି
କେହି ହେଇନାହାନ୍ତି ଆଉ ସେଠି appointment.
ଆଚ୍ଛା ସେଇଟାର କରେକ୍ଟନେସ ଦେଖିବା କଥା କାଉଣ୍ଟର ଭିଡିଓ ଫାଇଲ ହେଇଯାଇଛି
ନା କାଉଣ୍ଟର ଦେଇନାହାନ୍ତି
କାଉଣ୍ଟର ଦରକାର ହଉନି କଣ ହେଇଛି କହିଦେନା
I was continuing.
ଏଇନା ସାରିଦେବ କଣ ରଖିବା କି କଣ ହେଇଛି ଅର୍ଡରଟା କଣ ଭୁଲ ହେଇଛି କଣ ହେଇଛି ଆପଣ କେବେ ଆରାମ ଜଏନ କଲେ କଣ କଲେ ଟିକେ କୁହନ୍ତୁ
ଆମର ଗୋଟେ ରିଜିନ ହଉଛି ଆମକୁ ଶୋ କଜ ନ ଦେଇକି ସେମାନେ ଡିସଏନଗେଜ କରିଛନ୍ତି ସେ କହୁଛନ୍ତି we are unauthorized absence ଆମେ କହୁଛୁ during that period we are in medical leave. Annexure 4 ରେ I have also supplied the document.
देखिए so annexure 2 रे आपण appointed होले
My lord.
then
I was continuing there. Till in the thereafter they issued me show cause in the year 2017, and in the year 2018 they have disengaged me. The mo sethi show cause reply ta दवा पे time मांगी किंतु सेटा को से consider न करी मते disengage करछन ता अगेंस्ट मु अपील फाइल करथि अपील ले सेटा को कंफर्म करा हाइछि सीडीपीओ को ऑर्डर को जोटा व्हिच आई हैव साइन्ड.
Where is the order of disengagement?
That is annexure Melot 6 running page 25. Inviting reference to subject cited above, I am to inform you that as per the order of sub-collector Puri were disengaged from service with effect from 6/4/2018.
Let us see the order of the area.
That is collector, my lord, the running page.
Order of collector.
My lord. That is running page 11, my lord. The matter is taken today. Peruse the appeal petition filed.
Second paragraph. Second, move faster for the second paragraph.
Gone through the records, the appellant in this appeal petition claimed that the disengagement without giving sufficient opportunity of personal hearing and by ignoring the petition of the appellant dated 26/3/2018 non-speaking order of disengagement without framing of any charge and not providing the inquiry report along with the alleged show cause notice dated 13/3/2018. This is our plea, my lord. Peruse the written notes of argument submitted by the appellant. The appellant submits that the ground of disengagement is that on 9/3/2018, CDPO inquired the Anganwadi Center and submitted a report detailed to the sub-collector Puri stating that the appellant was absent from 1/1/2015, basing on which the sub-collector Puri on 12/3/2018 issued a notice to the appellant for filing of show cause within 7 days. On receipt of the said notice, the appellant paid for 1 month time through her advocate on the ground of her illness supported with medical certificate. But the sub-collector did not consider the same and disengaged the appellant on 6/2018. The appellant also mentioned the guidelines for selection of the Anganwadi worker on provision to disengagement of Anganwadi worker in Proviso 734 that an Anganwadi worker can be disengaged by the sub-collector if any serious or persistent lapse is noticed in her work. The Anganwadi worker will be an opportunity to show cause against the sub-collector. Further, the appellant stated that the center was functioning by the appellant from 2015 to 2017, except the period from 4/12/2017 to 22/6/2018. Is due to illness period of the appellant. Peruse the parawise comments report submitted by the CDPO go provide her office letter number 1033 dated 29/12/2018 along with its annexures. The CDPO go reported that the appellant Maheshwata Patnaik was working as Anganwadi worker for CORAM Anganwadi Center was remained unauthorized absent from her duties since 1/1/15 from the Anganwadi Center, as a result of which the local sarpanch alleged the fact before the collector Puri. According to the said allegation, the sub-collector Puri called for a report from the CDPO GOP by letter number 16073 dated 24/11/2017. The CDPO GOP conducted inquiry into the allegation raised thereon and submitted her report by letter number 613 dated 5/12/2017, stating in that Srimati Maheshwata Patnaik, Anganwadi worker of Koramanga Anganwadi Center, is unauthorized absence from Anganwadi Center since 1/1/2015 and she is staying with her husband on outside the state. The nearby Anganwadi worker, Srimati Mauna Dalai of Panchana Anganwadi Center, was kept in charge of Koramanga Anganwadi Center. After receiving the report from CDPO, GOP sub-collector Puri called for explanation from Maheshwata Patnaik by letter number 17653 dated 11/12/2017, and after receipt of show cause notice from Sub-Collector Puri, Mahasweta Patnaik had submitted her show cause, stating therein that she remained on leave on medical ground. As per the advice of doctor, on receipt of the show cause, the Sub-Collector Puri again called for report from CDPO Go by letter number 18161 dated 22/12/2017. The CDPO Go conducted inquiry and submitted her report to the Sub-Collector Puri by letter number 196 dated 9/3/2018, stating in that Srimati Mahasweta Patnaik, Anganwadi worker working for Koramanga Anganwadi Center, was remained absent from her duty since 1/1/2015. She has been called for explanation by letter number 613 dated 5/12/2017, but till date she has not yet joined at the Anganwadi Center. During the visit of CDPO on 9/3/2018, the villagers have submitted a written report stating therein that the Anganwadi worker was left her village on dated 1/1/2015, and at present she is residing in Chennai with her husband without any intimation to the office. The ICDS work for 6 packages services are hampered lot. Preschool awakening of children, immunization, DHND, referral services are very poor performance. After receiving the said report, the Sub-Collector Puri issued show cause notice to the Mahasweta Patnaik through CDPO Gov, but due to non-available of Mahasweta Patnaik in her village, the CDPO Gov served a copy of the said notice to her father-in-law and returned the served copy of the to the Sub-Collector Puri by letter number 247 dated 21/3/2018. After receiving the show cause copies from the CDPO Gov, Sub-Collector Puri issued direction to the CDPO Gov by letter number 4484 dated 6/4/2018 to issue disengagement order.
So, Mr. Ode, what is wrong in this order?
Well,
you have been given sufficient opportunity, and now giving you an opportunity would amount to empty formality, nothing. ଛାଡ଼ଛୁଡ଼ା ଦେଇକି ଯାଇକି ମାଡ୍ରାସରେ ରହୁଥିଲେ ଗୋଟେ ପଛରେ ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ଯୋଗାଡ଼ କରି ଦେଲେ ହବନି ଯେତେଦିନ ରହିଲେ ଆଉ
କଣ୍ଟିନ୍ୟୁ କରୁଥିଲି ଏଟା ପଲିଟିକାଲ ରାଇଭାଲରି ପାଇଁ।
ହଁ ଜଣାପଡେ ପଲିଟିକାଲ ରାଇଭାଲରି ତ ସବୁ
ଦେଇଛି ମେଡିକାଲ ସାଇଡ ମୁଁ ଦେଖେଇଛି
ସେ ମେଡିକାଲ ସାର୍ଟିଫିକେଟ
ଡକ୍ୟୁମେଣ୍ଟ ମୁଁ ଦେଖେଇଛି ଯୋଉଠି ମୁଁ ସାଇନ୍ କରିଛି ଲାଷ୍ଟ ଅକେଜନ ମାଇ
No.
ଏସକେ ସାହୁ ୱାଜ directed to file an activity document.
Very limited scope for the writ court to interfere. ହବନି କଣ କରିବା
6 ବର୍ଷ ପରେ ଆଉ
6 ବର୍ଷ ପରେ ଘରକୁ ଯିବେ ଆଉ ଚାକିରି କଲା ବେଳକୁ ଚାକିରି ଯଦି କରିବେ କେତେ ଲୋକଙ୍କର ଆଜ୍ଞା ଏଠି ଅନଏମ୍ପ୍ଲୟମେଣ୍ଟ ସିଚୁଏସନ ଯାହା ସେତେ ଯେ ଚାକିରି କରିବେ ତାପରେ ଛାଡ଼ଛୁଡ଼ା ଦେଇକି ଯାଇକି ଯେ ମାଡ୍ରାସରେ ରହିବେ 3 ବର୍ଷ 4 ବର୍ଷ ରହିବେ 6 ମାସର ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ଦେବେ ଇଏ ଜଣା ପଡିଗଲାଣି ପଢିଲା ବେଳକୁ ହବନି I'll dismiss it, I'll pass appropriate orders. I'll dismiss this application. Okay? I'll pass orders later. You can call it time to put on no Dakideva. The petitioner has approached this court with the following prayer. The case of the petitioner, briefly stated, is that she was engaged as Anganwadi worker of Koramanga Anganwadi Center under ICDS project GOP in the district of Puri, as per order dated 30/1/2010 of the BDO come CDPO GOP.
Maybe one thing, my lord, 1 minute. Last occasion I had filed an affidavit that I was continuing with certain documents where my signature is there in certain documents. Let my lord and senior to verify 70% ମୁଁ କଣ୍ଟିନ୍ୟୁ କରୁଥିଲି ବୋଲି ଦସ୍ତଖତ ଅଛି ବୋଲି ମୁଁ କହୁଛି ଲାଷ୍ଟ ଅର୍ଡରରେ ମୁଁ ଦେଇଛି ଆଫିଡେଭିଟ କରିକି ଡକ୍ୟୁମେଣ୍ଟ କିଛି ଦେଇଛି
Yes.
କପି ସର୍ଭ ହେଇଛି
Well, I'll grant to ସେ କହୁଛନ୍ତି ଯଦି ଠିକ ଅଛି if she has stated on affidavit that
ରିଜେକ୍ଟ ଯଦି ହବ କିଛି କଥା ନାହିଁ କିନ୍ତୁ
all it if she wants କିଛି ଅସୁବିଧା ନାହିଁ you take instruction. You don't have to file a reply, just take instruction. If there is any document available, then produce that document. Learned State Council shall take instructions with regard to paragraph 3, with regard to the amendments made in paragraph 3, with regard to the amendments made in the affidavit filed on 12/12/2022. List this matter on, what was the time there?
9th July.
9 July.
Published matter.
Item 24.
May it be. The petition has been filed at the instance of the wife for transfer of RCR petition from the Learned Judge Family Court, Baripada to Learned Judge Family Court, Bhubaneswar. Divorce case is also pending before the Learned Judge.
Yes, what do you say?
My lord, before there are two petitions, my lord. One is I have filed TRPC 412 for transfer of the divorce petition to the Baripada, and they have filed the transfer section 9 petition. Before the
There are two petitions. One is a divorce petition filed by the husband or the wife.
Wife.
Wife has filed. You have filed.
And
you filed it at? You filed that petition at?
At Bhubaneswar.
At Bhubaneswar. And you have filed a section 9 petition. You have filed it at Baripada.
Before the filing of that divorce petition, the wife already had filed a mat suit number 27 or 24 before the Learned Court, Family Court, Baripada, on the same ground, my lord, royalty, and that was dismissed on contest, my lord. And address of the petition of my wife was same, my lord. So as she is residing at the reduction of the Baripada, my lord. When the marriage has taken place in the Baripada, both the parents of the petitioner and husband and wife belongs to that village. Dorkholi, Post Panispada, and PS and Rasgovindapur. Both of them will start clear. And since after that, my lord, she had got the job and junior auditor, and she is working in now Bhubaneswar. She had left the house of the petitioner. The petitioner, her husband had taken every step to take her back, but she did not come, my lord. And the husband is also taking care of the children, my lord. ତା ବାହାଘର ଝିଅ ବାହାଘର ବି କରିଛନ୍ତି and ପିଲାକୁ ପାଠ ପଢଉଛନ୍ତି ଭୁବନେଶ୍ୱର.
Yes, Mr. Nanda.
Wife is working, government servant working at Bhubaneswar.
So what? Earlier you had also filed a suit.
No. It was filed. And was dismissed. Thereafter, both are living happily, my lord. And subsequently, again, my lord, they
what are you doing?
Advocate clerk, LIC agent भी काम करते हैं, advocate clerk.
Advocate clerk. Kooti.
Said Baripada LIC agent काम भी करते. These are missing.
Already you appear virtually. Everyday appearance तो रखा नहीं, you appear virtually.
Virtually मतलब del second के section 9 का set था, वो टाइट था.
Same कहीं अलग कहीं को. अलग कहीं वो दीना को केस sobre section 9
decide matter तो already decide है.
Section 9 and it is always that is the law. Section 9 application जो file लीजिए then that will be taken up at the first instance, then the divorce application will be taken up. That is the law. So दीना अलग कोटले कौन होगा ना conflicting orders ही जीवो.
Already matter has already decided, matter. Baripada family court matter decided the matter, divorce case.
So you challenge it. You challenge that on the ground of res judicata or whatever. Is that plea level?
My lord, the family court Bhubaneswar, my lord.
Yes.
That petition was filed by the Learned petitioner before the Learned family court Bhubaneswar, my lord. That the subsequent case is barred by res judicata.
What has happened to that petition?
And Learned family court Bhubaneswar stated that let me examine the issues first, and then after I will decide the matter.
All right, then we'll take it up after disposal of that petition. Because if
both the matters can be taken to
no.
Let him appear in the
Mr. Nanda, if a plea of res judicata has been taken,
yes,
and if it is accepted by the court, then that will
yes.
If a plea of res judicata has been taken and if it is accepted by the court, what is the consequence? The case goes?
Yes,
if the case goes, then the transfer application becomes infructuous.
Yes.
Isn't it? So it will be better to wait. Then counsel for appearing for the opposite party husband submits that in view of the dismissal of a similar application filed by the wife in the court at Baripada on merits, an application has been filed by the husband in the subsequent divorce application filed before the family court at Bhubaneswar, challenging the maintainability on the ground of res judicata. Stop. Said application is pending. Stop. Such being the case, list this matter
That order has passed, my lord. No, not pending. The Lord Family Court who said, let me first check the issues. Thereafter, I will decide whether the matter is bad by res judicata or not.
That is the question. That is what I'm saying. That's good. So what is the order passed in that petition?
My lord, let me read, my lord, relevant part, my lord. After hearing learning amicus query for both the parties and taking into consideration of the documents filed, it is to be noted here that Section 11 of Civil Code of Civil Procedure bars the trial of any suit in which the matter directly or substantially in issue in subsequent suit or in issue must be the same matter which was directly or substantially in issue either actually or constructively in the former suit. Admittedly, both parties have no dispute that earlier occasion mat suit number 27 of 24 was dismissed on contest between the same parties before the competent family court initiated by the present petitioner on the ground of cruelty. It is also seen that the present suit is filed by the petitioner showing cause of action subsequent to the dismissal of mat suit number 27 of 24 on 10/4/27. The learned amicus query for the petitioner also submitted that in the matrimonial suit, second petition for divorce can be found on a new facts by placing reliance on in the decision of the Hon'Ble Madras High Court. Apart from the submission of the learned amicus query for the petitioner, it found that from the case record that respondent entered in appearance on 5/12/2022 in the present case and before filing the statement filed the present section 11 petition with a prayer to dismiss the case with the petitioner on 11/1/23. Admittedly, no issue are framed in the present case to determine that the issue in the present case are same like in the former suit, which was decided on the contest between the same parties. So the submission of the learned amicus query for the petitioner that the present prayer is premature is not throw out of light. से dismiss माने prayer टाको dismiss करना से कोई चंद issue frame कला परे वो decide करबी से adjudicata होच ना.
When is the case fixed to?
12/10/23 को for WS फाइल करे पे कोई चंद.
तापर कोन होला?
हम फाइल कर दे WS.
तापर next date तक
तापर हो जाने को.
करबी पूरा करबी. Is this matter August को 21st August. In the meantime, learned counsel for the opposite party shall inform the court about the result of the application filed by his client in the court below regarding maintainability of the divorce application on the ground of res judicata. Yes.
Obliged.
Item 25. Sir, RCF interim order ଅଛି interim order.
Interim order this cases.
Continue. No, no.
ଆମ କେସରେ ବି ଏଣ୍ଟ୍ରି
adjournment ପାଇଁ ଥିଲା କି?
ଆଜ୍ଞା
ହଁ
ସେ adjournment order ଟା ପାସ୍ କରିଦବ।
ନାଇଁ ସେଇଟା ଯଦି adjourn ହବ ତାହେଲେ that petition may not be decided. So that case may continue below. That divorce case below. Where the petition has been filed.
Divorce case ରେ କରନି କିଛି କରନି।
RCF ଟା restitution of conjugal
ସେଇଟା কোন adjourn
Dita divorce application. Divorce application. Yes.
My lord, on last occasion, my lord directed for meditation of the matter. And the meditation failed.
Meditation no mediation na?
Meditation.
Meditation है सकल के ध्यान करियो है.
And it failed. And
the report of the mediator indicates that the mediation between the parties has become unsuccessful. Yes.
And the opposite party has filed the CP under section 13(1). And in the mediation, he started scolding the petitioner that when I don't like this color, sari, this color, police, why have you come here wearing this color, sari, etc. Again, normal.
Sir, each and every mediation I was present each date. That no such matter is happened. I was always present at mediation. each day, my personally.
Where is you want it to be transferred from which court to which court?
From family court Bhubaneswar to Cuttack. Petitioner is a penniless person.
You will appear through virtual mode. The petitioner has approached the court.
Petitioner has filed a 120 petition.
No, I'm not inclined to allow the prayer, Mr. Nanda. The petitioner.
ଟଙ୍କାଟେ income ନାହିଁ କୋଉ source
କିଛି ଦରକାର ନାହିଁ ଆସିବା ଦରକାର ନାହିଁ ବିଲକୁଲ ସେ ସେଇଠୁ ଥାଇକି ଭର୍ଚୁଆଲି କରିବେ କିଛି ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ
ଏଟା ତ କଟକରେ ରହୁଛି
ହଁ ରୁହନ୍ତୁ the petitioner she has filed this application seeking transfer of CP number 694 of 2023 pending in the court of learned judge family court Bhubaneswar bracket 1 2 to the court of learned judge family court Cuttack. Stop. Transfer has been sought on the ground that the petitioner is residing at Cuttack and is under serious economic hardship, for which it will not be possible on her part to travel to Bhubaneswar to attend to the case on the dates fixed. Stop. Considering the above ground, no, this court does not consider the above to be a valid ground for transferring the case from Bhubaneswar to Cuttack. As firstly, the petitioner is not required to attend the court personally on each date of posting of the case, and secondly, she can also seek permission of the court to appear through virtual mode if she so desires. In such view of the matter, I am not inclined to allow the prayer for transfer. Stop. The transfer application stands dismissed. It shall be open to the petitioner to seek permission of the court below to appear through virtual mode. Stop. Further, the court below shall not insist upon the personal attendance of the petitioner unless absolutely necessary. Yes.
Obliged.
Item 26.
Counter has not yet been filed by the state government and central government. This is a EGS scheme.
EGS.
Minor.
Right.
The government has given permission to open the school and the school has been running 4 to 5 years. After 5 years, school has been closed and the petitioner has filed this case before this honorable court for adjustment of any other post of the elementary education.
No, what is your prayer? Case of the petitioner shall not be declared both EGS and EGS.
See, GSI is a one, my lord, but the state government says that GSI is a separate.
So what are you are aggrieved by which order?
Order the demolition of the school. School has been closed.
School has been closed.
Closed, my.
You are one of the teachers.
My lord, we are the teacher.
No, who are you? What is your local standard? That is what I would like to know. So you had approved this court earlier?
My lord. Honorable they issue notice to opposite party, but they have not filed any counter.
Yes. This is after closure of that scheme.
Yes.
Yeah. What happened?
No instruction has been received.
And you are appearing from whom?
Union of India.
Union of India. You want to file a counter or what?
Yes, ma'am.
All right. Counter affidavit has not been filed either by the Central government or the state government? Please this matter.
16th July.
July, August.
6th August. 6th August.
Please this matter on 6th August. Counter affidavit if any be filed in the meantime.
Item 27.
Your Lordship, the petitioner charge sheet is there. Charge sheet को आइए charge sheet ऐसी जाइए हमें charge sheet को as the petitioner staying here in Cuttack area and he is afraid to go there at Rayagada trial, just the hearing stage. We are praying for transfer the suitable any type of a place suitable Gunpur or anywhere very nearest.
My lord, last day, Honorable Court directed to produce charge sheet, but not inclined to transfer the matter. And on my instructions, if the Honorable Court not transfer the case any of the state, nearest Sakshivan, this is a political case. Petitioner is the principal of the World College. The FIR lodged by the above 95 persons before the collectors. After 2 years pending before the collector, case FIR was transferred to police authorities. Police authority registered a case and some 164 also recorded. If you find out not inclined to transfer the matter, जो साक्षी मैंने आसवे ताकर आइडेंटिफिकेशन करिक साक्षी करा जाऊ आ मते पुलिस प्रोटेक्शन दिया जाऊ जीवा पे
पुलिस प्रोटेक्शन तो आपण पाई करी कि साक्षी आइडेंटिफिकेशन माने
से जतबे सब पॉलिटिकल सरपंच एडवोकेट
सुनो मिस्टर सोलंकी साक्षी बे तो लिस्ट अछि लिस्ट 33 जन को लिस्ट अछि 33 जन को लिस्ट अछि ताकर बापा ना इत्यादि इत्यादि सब अछि
तार प्रॉपर
आइडेंटिफिकेशन यू विल रेज इट एट द कोर्ट. You will raise as a matter of defense. Why should this court directly? You, it is open to you. You can always question the identity. Whether he is actually Rama, it is for you to cross-examine him.
नहीं से मु इंस्ट्रक्शन देली से कोन सेठी सब करम जे समन पाई कि जे आसो तार आइडेंटिफिकेशन दरकार नै से कहउछ
ऐसे ना कोर्ट आपन रेज करिवे कोन आई विल मेक दैट ऑब्जर्वेशन
हां दैट ऑब्जर्वेशन एंड पुलिस प्रोटेक्शन टू मी
police protection you have to seek police protection from the and if the court feels that you are required to be protected
it is necessary हम जाई पर न पर्यंत
कोई नहीं जो बड़ा कर्म करछन अपन
Evidence has given allegation
allegation हम डाउन के लीगल ये कर देलु तुम खाए पे देलु न
नहीं सेउडा तो गला
allegation एफआर माइलर से कहउछन कोन हमर अनेक गुड़ाई असुविधा थिले मध्य से असुविधार समाधान से प्रिंसिपल नै
এটা তো অলগা পাটা কিছু মুখ দেন ডিপিপি পর 12 পোস্ট কো হইছে
ফাটা যেবে
the petitioner is is the accused in कितने जरा CT number 33 of 2015 pending in the court of learned SDGM court of
special court my lord
pending in the court of learned special judge
ADJ from PO special court post
additional judge come with PO special court Rayagada corresponding to Rayagada PS case number 37 of 2015 for the alleged commission of offences under section
354 12 post court
354 bracket small a तापर II मैंने कैपिटल आई class 109 IPC read with section 8/12 of the POCSO Act. The Sorangi and counsel appearing for the petitioner forcefully submits that the petitioner is seeking transfer of the proceeding to any other court
or any other place
to any other place as his client apprehends danger to his life in case he appears at Rayagada, appears before the court at Rayagada. Stop. He further submits that the case being politically motivated, it is being politically motivated, it is possible that several persons may come forward to give evidence by concealing their identities. Correct. This court observes that in case the petitioner feels threatened, he can always approach the concerned police authorities and also bring the fact to the notice of the court and seek protection thereby. As regards the identity of the witnesses, it is a matter for the court to take note and decide at the relevant time. For the foregoing reasons, therefore, this court is not inclined to entertain the application for transfer. Stop. The transfer application stands dismissed.
Observation disposable
समझते हैं डिसमिस लिखा है कि तापर ऑब्जर्वेशन दिया उसे क्या है सोचो अपन ऑब्जर्वेशन दवा हम देबी अपन तो क्षेत्र नेबे तो बस it shall however be open to the petitioner to seek necessary protection from the police and the court in case there is any threat to his life. It shall also be open to him to bring any discrepancy relating to identity of the witnesses before the court. I'm granted with that liberty, whatever liberty wanted, I've granted.
My lord, says charge sheet offense with 3 SC/ST is also there.
Okay, read with 3 SC/ST.
But principal all are student, my lord. Now, जो political लोक मैंने सेमाने हरान करते ଆଉ ଟିଚର ମାନେ ଯୋଉମାନେ ରିଟାୟାର୍ଡ କରି ଯାଇ ଶିକ୍ଷା ଖରାପ ଲାଗିଛନ୍ତି ସେମାନେ ମଧ୍ୟ ସେଠି ରିଟାୟାର୍ଡ ହେଇକି ଅଛନ୍ତି ସେମାନେ ମଧ୍ୟ ଫଲୋ ଅପ୍ କରୁଛନ୍ତି ଆମକୁ ତାହେଲେ ୱିଟନେସ୍ ଷ୍ଟୁଡେଣ୍ଟଙ୍କର ଆମ ବିରୁଦ୍ଧରେ କହିବେ ସେ କହିବେନି ଏମାନେ ରହିକି ଗୋଲମାଳ କରୁଛନ୍ତି
I may beg pardon, my item 26.
Yes,
item 26.
ଆମର କେତେ ଚାଲିଛି ଗୋଟ
ହେଲା
Sixth August. Sixth August.
କି ଥିଲେ କି ସେ
Well, I was held up in another court.
Oh, they have kept it to 6th August.
Yes, my name may be
The name of CBS Raiguru, the
OP7.
what OP?
7.
Union of India. He reflected in the cause list who appears for the Union of India, opposite party number 7.
Okay.
Yes.
Item 29.
Yes, please.
I prefer next week also.
Next week as preferred.
The correction is required, it is in the board, my lord.
Yes.
The correction of the order of your lordships, the year has been changed. There is nothing in the cause
Correction
list.
upon his
An entry order may kindly contact.
into order to continue.
Oblige, lord. Item 30.
My lord, second item, sub-item, he has not supplied the copy. I pray for 1 week after, let them matter be disposed. Copy ଟା ଗଲା ଡେଟ୍ ରେ କଥା ଆପଣ ଦେଇନା TRP ସେ 46 ଗୋଟେ ସପ୍ତାହ ପରେ ଆସୁ ଡିସ୍ପୋଜ ହେଇଯିବ
This is matter 1 week after. Copy of the transfer application be served upon the counsel for the other side. Yes.
Already served.
well just now sir
A specific date, madam.
See date cut. Date cut 1 week after.
The 16th July.
16 July.
okay
Item 31.
litigation by purpose
Into order to continue.
In this case, your lordship directed to the state council, my lordships, to take instruction as to whether from 2012 the seniority can be counted or not. Then say the diploma in special
You have filed legible copies of the show cause. You were directed to file legible copies of the show cause notice dated 17/7/2021. And the reply that two of the petitioner dated 27/2021 by tomorrow.
My lord. Yes, yes, that already filed, my lord.
Yes.
We have already filed our counter.
Counter not, counter copy not given.
Counterfile is it is on record?
ମତେ ଦେଇନାହାନ୍ତି ସେଇଟା। ନାଇଁ ସେଇଟା
ଆପଣ କହୁଛନ୍ତି
ନାଇଁ
ମୁଁ
ସେ
ପାଇଲି।
ଅଲଗାଟା ମୁଁ ଭାବିଲି ମୁଁ ଏଇଟା
That a copy of the counterfile filed by the state is served upon and counter for the petitioner in course of the day. List this matter next week.
let's say fix date.
Next week, next Tuesday ଆସିବ।
Item 32. One pass over the
କହିବ ଡକାଅ। Yes.
First minus 7776 of 2024. My learned friend must have gone through the petition.
आइए।
I'm sure that he cannot have an objection.
कौन है जितने?
But here in this case, the lordship had allowed the treat petition.
Yes.
There is, according to the petition, there is a typographical error. And your lordship may come to the final paragraph where it seems so.
Final paragraph of the judgment.
Yes.
ଖାଲି ଦେଖଉଥିଲେ ପରା?
ମୁଁ ଯେହେତୁ କପିଟା
କପି ନଥିଲା
ଥିଲା ବୋଲି ମୁଁ ସେଥିପାଇଁ ମତେ ଦିଆ so ଏଟା page number 22
last 4 lines.
ପ୍ରଥମ line ରେ resultantly the writ petition is allowed. The impugned order under annexure 3 is hereby quashed. The opposite party authorities, particularly opposite party number 1, is directed to pass necessary order to extend the benefit of the carrier advancement scale of pay in favor of the petition by computing the same from the approved date of their appointment without deducting 5 years of the said date. So here your lordship mentioned that it is the approved date of the
approved seat allowed tole likhla since the benefits have already been granted by deducting 5 years from the date of receipt of granted aid. The dues admissible with
Approved date of appointment.
Sir, it a point.
Directed to pass necessary orders to extend the benefit of career advancement scale of pay in favor of the petitioners by computing the same from the approved date of their appointment without deducting 5 years from such date. Since the benefit has already been granted by deducting 5 years from the date of receipt of granting aid, the dues admissible without deducting 5 years from the date of grant of receipt of that. That is, I want approved data.
But man, though my lord, your lordship, as per my understanding, my lord, in the first part, your lordship had specifically observed that what is the date of entitlement.
No.
And with respect to the second part, I think, my lord, that your lordship had specifically stated that what it has been done.
ସେଟାକୁ କର ନାହିଁ ବୋଲି କୁହାଯାଇଛି।
But it is
clarified.
Yes, it is in terms of the first.
It may cause confusion. Will clarify it. Yes. Since the benefits have already been granted by deducting 5 years from the date of receipt of the dues admissible shall be granted by deducting 5 years from the date of approved date of appointment. Ethical
Ethics.
Considering the submissions in paragraph 15, the last sentence of paragraph 15 be modified as follows. Be modified as follows. Since the benefits have already been granted by deducting 5 years from the date of receipt of granted aid, the dues admissible shall be paid to the petitioners by deducting 5 years from their approved dates of appointment as early as possible, preferably within a period of 3 months from the date of production of certified copy of this order. ହେଲା କଣ ଭୁଲିଗଲା?
ମୁଁ ବୋଧେ ଭାବୁଛି ଏଟା ତ ମୋ ଏଗେନଷ୍ଟ ରେ, କିନ୍ତୁ ଭାବୁଛି ସାର୍ ଟିକେ ଭୁଲ ହଉଛି। ଭୁଲ ହଉଛି କଣ, ଉପର ପାରାରେ ଆପଣ ଲେଖିଛନ୍ତି ଯେ ୱିଦାଉଟ୍ ଡିଡକ୍ଟିଂ, ତଳରେ ଲେଖିଦେବେ ଯଦି ଡିଡକ୍ଟିଂ ଦିଟା। ମୁଁ ଉପର ସେଣ୍ଟେନ୍ସ କଥାଟା କହୁଛି, ମୁଁ କହୁନି ଯେ ସାର୍ ମାନେ ମୁଁ ଆକ୍ସେପ୍ଟ କରୁଛି ବୋଲି। Your lordship's view is that nothing is to be deducted.
Nothing is to be deducted.
So ଏବେ ଯୋଉଟା ଆପଣ
the dues admissible.
Can you say what are admissible?
The dues admissible
that is a challenge.
shall be paid by computing the same from their approved dates of appointment. सेटिंग लिख दो. By deduction it will create confusion.
From the date of
by कौन लिख लो? For the author, since the
have already been granted by deducting 5 years.
Deducting
5 years from the date of receipt of the continued.
Comma.
The new is paid by computing the same.
Same from their approved dates of appointment. From the approved dates of appointment of the petitioners.
Yes.
तब जा लिखा है as early as possible इत्यादि इत्यादि.
That has been defined in the previous paragraph.
तो so clarify करते हैं. Those who are admissible without deducting 5 years from the receipt of granting net.
हमने positive कर दो इतना negative टेस्ट हमने positive कर दो. Computing it from the date of the
approved date of
appointment
is to be granted. Yes,
I think that will be.
Yes. I think मुट्ठी क्या उत्तर सुनी.
हाँ सुनो.
The benefit already deducted by deducting 5 years from the date of receipt of granting at one but which admissible shall be paid by computing the same to their approved dates of appointment by deducting.
How do you do?
Approved date of appointment.
Approved date of computing
the petition.
Sir,
computing the same from the approved dates of their appointment.
Appointment. Yeah.
So ठीक है.
Full stop.
Within such and such time.
Yes.
All right.
33. Let's say confused, sir. At least I am confused.
77 तो नहीं.
Actually, along with the
other matter. Other matter. Okay.
Other matter. Sir, say the prayer relief was something else, though that is identical, but both are had together. You'll also quashed Annexure 6 and Annexure 3. I'm sorry. Annexure 3 is the sanction order, sir. If that is quashed, then I will not get anything. Writ petition is allowed, everything, but in the same right allowable, sabu topsy turvy. I have categorically described it in my application. My prayer was something else.
What was your prayer?
My Lord?
What was your prayer?
My prayer, my Lord, I have issuance of writ to the opposite parties to allow the increments earned by the petitioner for the years 2002, 2003, 2004, and for a direction to the opposite parties 1 and 2 to grant senior lecturer scale of pay in favor of the petitioner with effect from 1/6/1993 on completion of 7 years of teaching service and to grant 2 additional increments to the petitioner in lieu of the acquiring MPhil qualification to grant the petitioner the selection grade teacher scale of pay with effect from 1/6/2001 and for fixation of pay of the petitioner in senior lecturer scale of pay with effect from 1/6/1993 in the scale of pay 3,000 to 5,000 and the payment of thereof, the fixation of pay of the petitioner as per college teachers rules 2001 with effect from 1/1/96 in the senior lecturer scale of pay, that is 10,000 to 15,200 instead of the fixation of pay made by the government in the scale of pay 8,000 to 13,500 with effect from 1/1/1996. The petitioner also for the pay for a direction to the opposite parties 1 and 2 to fix up the pay of the.
Let us hear it again.
Sir?
Let us hear it again.
Yes.
Let us hear it again.
That is to be reheard, my Lord.
Then, because I thought that it was connected to that.
I knew that because both are had together, that is why they should be reheard, my Lord.
I will recall it and we'll have to hear it again.
Yes, that should be reheard.
WPC list this matter on what a date could papa.
Sir, upon your content, I am prepared.
Next week, Korea?
Yes.
All right.
Give us that.
Next week?
Next week, how, sir?
Separate kuri karu. Arada ta hai na or modification hai na. Yes.
Next week, sir. 2nd July.
33? Chalo.
So, item 34.
This is that CRLMA, which my learned friend said was.
None
I
appears,
don't appear in that.
none appears on repeated calls.
No, your lordship may see the order. It has been disposed of on long since.
This
CRLM was disposed of.
And if it
But
was
what order
disposed of, why was it asked to?
No, what order has been passed?
No, what order has been passed? How are you to know about it? You should know.
Considering the no, that bail appeal, bail appeal, which was dismissed for non-prosecution, was restored to file.
So it was exist.
It has been restored to file already. BLAPL number 6216 of 2022 has been restored to file. That is not in list today. That is not in the book today.
No, madam.
6216.
No, madam.
So these are
With that connected application, because I had given that.
Item 42.
In item 42, I had given the number.
42 is this number. Another way.
No, 42 is the separate application file.
My lord.
Now there are two applications pending.
Yes.
So सेटा restore हो गया. Restore हो गया. Second application
In 5062, I have given 6216 number also, BLAPL 3.
But that is pending. We'll call that matter tomorrow along with this. Can say if that is pending, then that will be a technical hurdle. Will it not be? Whether it is pending or not, that we have to find out. 6216. A कौन सा कितना number पहले?
6216.
देख लो जी. BLAPL number. BLAPL 6216 of 2019. 2019 था?
2022.
2022, sorry. ये ना क्यों? Last one. Dismissed for non-prosecution. तब restore ही था मैंने. It is pending or कौन?
Right.
What to do?
I am only reminded of stories which I have read, my lords. That donkey, during Jahangir's reign, he was hungry and ate the rope of the bell of justice. So the emperor's sleep was disturbed. And he woke up and gave justice by beating up the owner of the donkey. A few days back, a trial court granted bail to somebody. Without that order being uploaded, the High Court stayed that, my lords. So the situations are changing, my lords.
How can a bail order be stayed?
I don't know. It has
Please enlighten me. I want to know. Everybody is asking that question to me. But many people have
There is only one judgment which says that it cannot be done. That is the judgment of this court.
It can be cancelled.
A full bench judgment of this court says that when an order of bail is granted and it has not worked out, it cannot be interfered with.
No, it can be cancelled.
It cannot be interfered with unless and until the accused has come out of custody.
So
that is the full bench of this court.
That is now that has seized the imagination of the entire country now.
Yes.
How could it happen? I mean, anyway, let us not
It will
talk.
happen. Nowadays, we not say it happen.
So what to do now? This is a technical hurdle.
And now your lordship will decide.
No, because that I will call for that. If nobody appeals, I will reject it. Either of the application has to be considered. Either one of the.
Surprised me, lords, that this CRLMA was allowed, me, lords. I don't think anybody has appeared when it was allowed also.
CRLMA. Maybe.
And one other thing I remember, my lords.
No, somebody had appeared. Mr. S.K. Jana. The petition application was restored. I have myself restored it. I have written it. So this technical objection, to overcome the technical objection, let us call that application to the board. We'll call it tomorrow.
Tomorrow I am not available.
When do you want then?
Maybe day after tomorrow, earliest.
Day after tomorrow? How? Let's just matter day after tomorrow. Issue जो item कितना है अपना करो? 42 रे. Let's just matter day after tomorrow along with BLAPL number 6216 of 2020. 6216 of 2022. है ना? अब यही जो CRL लिमिट है, CRL पर छाड़ दे. CRL कहीं किसी से already allowed ही है, no further needs to be passed. Okay, yes.
Item 35. Lordship, 35. Your Lordship had granted me interim bail. I have surrendered to custody, my lords. The operation could not be held scheduled, my lords, because
As per certified copy of the surrender certificate filed in the court, the petitioner has surrendered to custody on 18/6/2024. This surrender certificate be kept in record. CORAM को कह दो.
so there is a date has been fixed to the 28th, my lords, for his tests to be conducted, my lords. Dear Lordship, pass this over.
Pass over.
I think item 36. IA. Oh, IA. Your Lordship, I see the document is annexed to the IA.
आइए कितने?
I have filed IA 709.
Yes.
2024.
Second आपको जीवो कौन सा? Yes, item 38.
38. I have filed a IA.
Sir, what is your good name? No, why? I have a reason to ask you. What is your good name? Pal. So somebody was making a mention on your behalf. He said he pronounced your name in a different way. So I thought probably he may be a different person. He said Paul.
No.
But when I asked you one day, you said it was Paul. Today you are saying Pal. So it is written Paul. Actually not a con.
In Odia,
Paul लिखिन तो से कौन?
the interim bail is granted for 4 weeks, my lord.
कौन थे?
My lord, in BLAPL number.
Ramesh Masara.
No, no.
No, don't. तो इसे item कितने?
38, my lord.
38 is not yours.
May I please, Lordship? Last order, your Lordship direction to obtain this deposition, ma'am. I supplied in the Lordship.
You have been inaccused.
Yeah.
He is the man.
Victim has been examined.
Yes, my lord. PW1 is the victim.
PW1, my lord, can you see, my lord? Para 17, my lord.
Oh, it's a suggestion. Paragraph 17 is a suggestion.
No, my lord, para 17, my lord. Deposition number 1, my lord.
PW1 though? No. It is not a fact that I am not at all in the alleged house of the informant and I reside along with my original father. 33. Yes. It's a con the
My lord, the informant.
She has stated in para 2, my para 2.
You accept. कथा भी hostile लीच. Yes. लेकिन भी जति कोई चीज़ है ला.
हाँ. तो para 2.
आगुल पर रिजेक्ट ही चला.
आगे.
अपन कोई तरह विक्टिम एग्जामिन पर ऐसे करी होगी.
आगे.
para 2 रे विक्टिम जा कोई चीज़ सरला. The petitioner is in custody since
2/2/21, my lord.
2/2/2021 in connection with such and such case. You are for the informant. His earlier application for bail was rejected by this court as per order passed in BLAPL number 1386 of 2022. granting him liberty to renew his prayer after examination of the victim. Stop. The victim has in the meantime been examined as PW1. Though she has turned hostile, yet her testimony still contains still she has implicated the petitioner. Learned counsel for the petitioner submits that the petitioner has been in custody for nearly 3 years, for which several domestic problems have surfaced, which require his personal attention. Considering the submissions as above, and the period of considering the submissions as above, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 1 month. 1 month.
Pardon, my lord. Here, your lordship has issued notice. That may be reflected. Notice was served on 29.
In case of the notice on the victim notice on the informant was served on
29/4/24.
29/4/2024 as informed by Learned State Council. Yes, Mr. Pal.
Item 33 just passable.
33. Oh, he's basically so it passable both look up here. No, second hour in the list of the whatever.
Item 39 and passover.
Passover.
Item 40.
My lords, it is my third bail application, my lords. First bail application, your lordship pass order.
Notice has been served.
Notice has been served today, my lord. Today itself.
All right. Learned State confirms that notice on the victim was served today. In order to grant opportunity to the victim to appear. Is this matter? What did it for?
9th July.
On 9 July.
Item 41. May I please, Lordship. Lord, the Lordship was pleased to have this matter, my lord, and instructed my lord to
whether the petitioner stand on the same footing as Dhannadas.
Another co-accused persons, my lord, who also stands on the similar footing as
Yes, he stands on the same footing.
Yes. In the meantime, another two accused has been released on bail.
Learned State Council fairly submits that the petitioner stands on the same footing as co-accused Dhannadas.
Dhannadas and other.
Dhannadas, who has been released on bail, as per order passed by this court in BLAPL number 13876 of 2023. Order pass kar do, all right.
Item 43.
My lord, the petitioners along with others are accused in Chendipada PS case number 524 of 23 under section 20A1.
Implant, my lord, similar order earlier passed.
Same order. Same order.
Obliged.
Item 44.
May I please have a second? The offense is under section 20B2 of NDPS. In the meantime, the
Transfer to bail.
granted bail by your lordship.
कौन है जी देखें?
One Ranjan Bira has been granted bail. He is on similar footing on the confession statement of coercion.
Same order.
Only allegation they have collected from this. Yes. Item 45.
May I please, yours. Well, the case is under section 420 of the Indian Penal Code, madam. In the present petitioner is a lady. An allegation against the present petitioner that the account which has been used by the other accused person, that is in her name, madam. And in between, madam, the principal accused Narayan Mahanti and one Shankar of the arrest.
No, their application was rejected, granting you liberty to approach if any cause of action arises.
Madam.
So, have you been implicated?
Yes, madam.
How?
In forwarding report, madam,
Your name is there.
My name is there.
Let us see.
Madam.
Forwarding report.
Forwarding report certified copy there.
कौन करिए तले? Forwarding. Earlier application was rejected specifically on the ground that you are not implicated. You are granted liberty to
FIR lodge है ना. before
have not been named in the FIR lodge is ଆପଣଙ୍କ ନାଁ ନଥିଲା।
ନାଇଁ ନାଇଁ FIR lodge ହେଇନଥିଲା previous bail application ବେଳେ FIR lodge ହେଇନଥିଲା your lordship had granted liberty if FIR has been lodged then renew his prayer that is the
no
ABLAPL 129 of 2000
the petitioners have not been named in the FIR.
If any cause of action.
There is no other material record to show their involvement. What you are submitting something else?
My lord 129 of 2024 before registration of FIR man PS case number भी नଥିଲା ତାହେଲେ bail petition is available.
Release this matter tomorrow along with ABLAPL number 129 of 2024.
may I supply copy of
ଆସୁ order mobile ନାହିଁ କି? Let the case record come. Let the case record come. Let us see. ସେତେବେଳେ କଣ submission କରିଥିଲେ ଆଜି କଣ submission କରୁଛନ୍ତି Mr. ପଟ୍ଟନାୟକ?
ନାଇଁ ମୁଁ ସେତେବେଳେ ମାନେ no course action ପାଇଁ କହିବାରୁ ମତେ ଲିବର୍ଟି ଦିଆଯାଇଥିଲା ଯେହେତୁ FIR lodge ହେଇନି
ଦେଖେ yes
Item 46.
କାଲି ଆସିବ ଅପ୍ଲାଇ ଯାଉଛି
item 46
Please, man. Lordship, the alleged offences are under section 363, 365, 323 and 34 of IPC. On the last occasion, Lord and Counsel for the State were directed to bring
Yes,
the case.
my lord. He has been implicated by the confessional statement of one Swagat Sekhar Sahu, Lucky, who is the driver of the victim. And on his direction, the present petitioners, along with others, they have kidnapped and the persons
So we can
has
put the
been
same order?
released on bail has
we can pass the same order?
Yes, ma'am.
All right, same order.
Item 47.
Item 47, my lord, similar order is annexed to my lords. TSCST Act.
47, 40.
47 same order. 48 same order.
Item 49.
CRL में regarding cancellation, CRL में regarding cancellation. ये पास ओवर करता है तब देखिए आप। You are in which matter? 50 अच्छा 50. 49 है ये. Yes. Cancellation of bail. What way?
50 matter cancels.
Yes.
My lord, I have paid to cancel the bail, my lord, 12/12/23, my lord. In ABL penal 14538, my lord. My lord, here the petitioner filed the application on under section, my lord, 160 number 3900/20 before the Royal Court below, my lord. In this matter, 15/3/2021, my lord, the accurate date of appearance has been fixed, and my lord, then my lord, cognizance has been taken, and the accurate file CLMC number 572/21 for passing the cognizance. Therefore, after my lord, summons has been issued, she did not turn to appear. Then my lord, again fresh summons has been issued. 3 times summons has been issued to her. She did not turn to appear. Then my lord, NBW has been issued. It has remained for 2 years. NBW she did not turn up. Finally, she appeared, and my lord, while the matter stood thus, she filed an application. This present application before the Hon'Ble Court for his bail, my lord. By suppressing that the earlier application which she filed for passing the cognizance, she did not mention in that. And while placing the matter for passing the cognizance, she asked for restraining the NBW, my lord. This court did not turn up. The go and after she, my lord, then the second time it has come, it has become non-prosecution, dismissed for default. The CLMC. Then it has been restored after. With the Honorable Chief Justice Court, she did not turn. Then it has been restored. It is now pending, my lord. While my lord, after my lord, this bail application, she has been allowed by the Law and Court below to go on bail with some terms and conditions. After she has get the bail, my lord, before the Law and Court, my lord, while the petitioner is not in her house, she has come from my lord Chhattisgarh, along with 2 local coal mafia. She threatened the petitioner Bhubaneswar, taken away all her documents from the court premises, and my lord, 2 persons of the local lawyer, there Bhubaneswar, they have my lord opposed her and rescued the documents. Thereafter, my lord, come to her house to at the NALCO office, and again the my lord making call there, and while the matter go to their my lord home district, my lord, at home district, the present petitioner's wife gone. There also, my lord, she has been threatened.
Have you lodged FIR? Have you lodged FIR against the accused?
Nothing.
My lord, no FIR has been lodged because I have taken all those transfers. Because FIR because
complaint has যদি আপনাকে ঘরକୁ ଯାଇକି if according to you
complaint ଦେଇଛି କିନ୍ତୁ
sir ଶୁଣନ୍ତୁ
complaint ଦେଇଛି ମାନେ
complaint ମାନେ କୋଉଠି ଦେଇଛନ୍ତି
police station ରେ ଗୋଟେ ଦେଇଛନ୍ତି ଏଠି ଆମର
that has not been registered hey that is the FIR
register କରିନାହାନ୍ତି
so
I will ask him to go for the processing that
prayer for ଦେଖନ୍ତୁ ECR prayer for cancellation of bail has been made on the ground that after being released on bail the accused opposite party number 2 went to the house of the petitioner and threatened him.
I mentioned
and also snatched away and forcibly took away several documents.
Come to the witness box also, my lord.
সেটা আপনার that is for the court to decide. In this regard, the petitioner claims to have submitted a complaint before police station.
Taking instruction, she has stated that she has made a complaint. I will take instruction on that government. But I have said, but she has been settled with me because I asked him to give the complaint because she has no copy.
Sorry, sir.
That is the whole problem.
Liberty is one of the most cherished objects under the Indian Constitution. Once the court has exercised the jurisdiction, unless you come up with a
because
yes, he has violated he has that ଶୁଣ ଗୋଟେ କହୁଛି ପରା କୋର୍ଟ କହିଲା ବେଳକୁ ଟିକେ ଚୁପ ରହିଯିବା କଥା ବେଟର ନା ନାଇଁ ତାପରେ ଆପଣ କହିବେ ମୁଁ ଶୁଣିବି ଆପଣ କହିବେ ମୁଁ ଶୁଣୁଥିଲି ଚୁପଚାପ have that mutual respect. So when a person has been granted bail, if he violates the condition, yes, that can be a ground for cancellation of bail. But where is that concern? ଆପଣ କୋଉଦିନ complaint ଦେଇଛନ୍ତି complaint
she has to appear each and every day before the court.
That is what the court decide. How are you affected?
NBW has been issued to her.
But that's all right. That is all right. She will be arrested. She will be arrested. How is that? How will this?
But she cannot threaten me in the court premises.
So that is what I am asking you. She cannot threaten you. She cannot threaten you. It's all right. But have you lost the FIR in that regard?
The copy will repeat. So
No.
I'll produce that copy.
No, nothing.
I will.
You should have been ready with that. If that is your case, you should have been ready with that.
I'll produce that copy. Those copies I will produce. I will ask him to produce the copy or to take recourse of the law that how FIR should be lost. She has stated me that.
On query, the learned counsel for the petitioner is unable to satisfy the court.
I'll produce that document.
As to if the petitioner, as to in which police station such complaint has been lodged. Learned counsel for the petitioner wants some time to take instructions in this regard. Please this matter next week. Next week. All.
But can I say, but the petitioner's husband is at my lord working outside the state, my lord. She has been transported in the meantime. She hasn't adjusted because there is no staff.
So what are you saying?
The Koraput Ramanjur.
9 July.
But
yes.
14, my lord.
I'll take up all the passable matters.
My lord, I have a difficulty, my lord.
Item 14.
Item 14. It's a passable matter.
Item
16. Can we both have a case, my lord, which has been passed over in North Africa?
Your associate asked for a passover. Mr. Das has passover.
ଆମ ଦି ଜଣଙ୍କର ଆଉ ଗୋଟେ case ଆଉ ଗୋଟେ
No, but you want it to do next week. As painful is this matter next week.
Item 16 also my lord pass over.
16 passover. Next week. 16 next week.
Item 18 also.
I'll take up.
ठीक है pathology problem no.
Your associate will argue that matter.
That she cannot because government.
Why she cannot? How can you say you cannot?
She has not gone through that.
No, she will go through it. She will address the court. I will address it tomorrow. All right, next week.
Special mention matter will come after.
Especially assigned matters will come.
In item number 16, my lord, as per the lordship direction, we have already filed an additional counter, my lord, counter affidavit.
Next week we do it.
I'm file for this. Hard copy.
Hard copy of the counter already e-filed.
Yes.
Be accepted. Item 16. Yes, Mr. Hon'Ble, your matter is, you have received copy?
Yes, my lord, I received.
Anything else? Other matters when खाली specially assigned special notice or the matter. First we will take up special notice, then इधर adjournment की चीज़ है ना? Pass over होगी. Your matter has been passed over. We'll take it up after that.
Lord, this is a matter, my lord. My lord, where in the year 96, the petitioner joined as regular junior typist, my lord. In the no, my lord, the urgency is that I am seeking for transfer, my some promotion. I need to be considered within the zone of consideration, and my retirement is on this date, the 30th/6/2024, my lord. And my, no, my lord. My lord, I have to just show my lord the my lord, kindly have a glance to. My lord, that is a order, my lord, at page 5, my lord. My lord, when after I joined 96, in the year 2009, one gradation list was published, where my name finds place at serial number 31, my lord. Thereafter, another revised gradation list was published in the year 2010, where my seniority was altered, for which I approached the learned tribunal, my lord. My lord, the order is at page 5. The operative portion is at 7. My lord, found that page, my lord? Yes. My lord, may I read the operative portion? On hearing the learned counsel for the applicant, the learned standing counsel, the OA is allowed. The government order dated 27/1/10 at Annexure 4, including the private respondents in the common gradation list from the date of their initial appointment under the World Bank funded scheme, and final gradation list dated 10/3/2010 at Annexure 5, by including the name of the private respondents above the applicants, and the order of the government dated 10/6/2010 at 11, rejecting the representation of the applicant for restoration of his seniority, are quashed, my lord. The private respondents shall take the seniority in the common gradation list on the basis of their final absorption in government service, and they shall be placed at the bottom of the gradation list of the junior typist, which was in existence on the date of their absorption. My lord, now the point is here, my lord, the direction, main direction, the entire exercise be completed within a period of 6 months from the date of receipt of copy of this order, my lord. Yes, my lord. My lord, that means this order needs to be complied by 10/6/13, but to my misfortune, they preferred a writ application, the private respondents. My lord, and in the writ application, that got disposed of in the year 2021. That is also at page 10. Not inclined to interfere. My lord, thereafter they did not take any steps for more promotion. Yes, my lord. Thereafter, they did not take any steps for my promotion, my lord. Thereafter, I again represented before the authority. And when they did not pay any heed to my objection, my application, I approached this honorable court, my lord. My lord, kindly have a glance to Annexure 3 at page 25, and the operative portion is 27. Here it is also, it is made clear that in the event it is found that the petitioner is entitled to the benefit as has been decided in the aforesaid writ application, this 9157, when they did not give me promotion after 2 orders in my favor, I filed a representation. When they did not take any steps, I preferred this writ application before this honorable court. And after hearing the matter, and before opposite parties presence. Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. No, my lord, what happened thereafter? My lord, they issued the gradation list on 13/5/2022 at page 23. That is on 13/5/2022. My lord, kindly have a glance to page 24. My serial number is at 3. Yes, my lord. My lord, thereafter what happened? Some other employees who were in the below the gradation list, and those respondents were above me, they were again above them, and they filed a writ application, my lord, for which this got delayed, and ultimately they gave me promotion on 12/22/12/22. That is at page 28. My lord, there is no illegality on my part. Because of the inaction of the opposite parties, which I want to draw before your lordship, because of their inaction, I got promotion in a delayed period, my lord. That is 12/22/2022. Thereafter, I preferred after 2 years when I'm going to retire, I filed a representation to give me the next promotion. Now they are saying, just because you are retiring on this month, you are not completing for the 6 months, because 2 years needs to be required for the promotion, my lord.
There's no provision for relaxation.
No, my lord. My lord, kindly have a glance to page 32. This is the rule, my lord. At least 32. Rule 14, my lord. At least 2 years of service. Yes, my lord. That has been redesignated as superintendent, my lord. Yes, my lord. My lord, my only submission before your lordship.
This qualifying service is the feeder card, which is 2 years.
Yes, my lord.
There's no provision for relaxation.
No, my lord, there is no, because they can say, my lord, it is not in the rules, my lord.
In
My
fact,
lord, the thing is that
in fact, a counter has been prepared and is being filed. He filed the hard copies there.
That's all right. But because of her delayed promotion, she claimed that
Yes.
she cannot be get. Had you granted her promotion in the due time, then she would have clearly.
After the learned tribunal's order.
Yes. Because the tribunal's order stands.
Yes.
That is in
After being confirmed by the Hon'Ble court.
So what now what interim order?
Let it be finally disposed
my
of.
lord, खाली मत consider,
Not today.
at least consider करନ୍ତୁ ଆଉ 4 दिन ଅଛି. Consider करନ୍ତୁ କାରଣ ମତେ ଏବେ zone of consideration ନଉନାହାନ୍ତି. And my lord, 4 vacancies are there, my lord. My lord, can I suggest, my lord, with a limited having, my lord, may I say ki let them consider, this may be kept pending, and if I retire, that may not be a bar for my.
The application is pending, so why would it be a bar?
My lord, it happens, my lord.
Ultimately.
Prior to your retirement.
Yes, my lord. Yes, my lord.
Retirement benefits.
My lord, at least खाली more with the interim order दरकार, let them consider within 3 days. My lord, IA only for not to take any coercive action. My lord, my prayer is that ki to consider me within the zone of consideration.
No,
Let them consider at least for.
And say that the pendency of this application shall not be a bar to consider your application or consider your promotion. More so as you are going to
Return on
4 weeks.
And
4 days.
And my lord, in the coming, whenever the DPC will be held. No, my lord, more just some. Commission which जब भी DPC consider.
How? By the time you would have been retired. Relaxation so how can that order be passed?
My lord, but admittedly,
I will pass it in this manner. That this will not be the pendency of this application shall not be a bar. If the authorities decide to consider your case for promotion.
If my learned senior will, my lord, agree, then they might consider my case for.
That is what your lordship is observing.
Please consider, because in the absence of rule, the order demotes the rules cannot be passed.
No, my lord, I bow down, my lord. My lord, only that keep. In terms of learned, in terms of tribunal's order and High Court's order, let them consider.
Because of mention you made that it's urgency. That we take up again. Then come to the petition. But it's that Let's pass on. Then 12. It's passed way back on 10/12 and directed the authorities to prepare the additional list as per observations, as per observations made. Said order vis-a-vis the petitioner and other responses. It is further submitted because of the said order of the tribunal having been challenged before this court. Was confirmed. The authorities instead of did not compare the order for as long as 10 years. As a result, the petitioner was differently from being considered for further course.
Is content.
Considered to the course of Number 88. Number 7. Question of application of the petitioner's promotion. The matter to be decided in the litigation. And unless same is decided in her favor, in his favor, in her favor, the petitioner cannot get any vested right for being considered for promotion to the nationality.
Hard copy copies out today. Along with an IA, where the prayer has been made to vacate the interim order dated 25/2024. Along with an IA.
The matter is otherwise ready for hearing. This matter around 13th August 2024. In the meantime, directed that in the meantime. The pendency of this examination shall not be a bar for the authority to consider the case of the petition for promotion to the next higher post, having regard to the contentions raised in this application and considering the fact that she is due to retire on complaint of this.
Grateful.
Hard copy we kept on the.
I don't know to.
This case had challenged the order of transfer under Annexure 5 at page 18, my lord. Petitioner is a senior radiographer. My lord, he has been transferred. My lord, I have challenged this transfer order on two grounds, my lord. First is the CDMA is not the competent authority to transfer. Petitioner is a senior radiographer. Competent authority is the director, my lord. And second ground is the petitioner is a senior radiographer and senior radiographer post is available only in district headquarters hospital. In the subdivisional hospital, senior radiographer post is not available, my lord. Your lordship. Prior to 2019, senior radiographer post was treated as a district cadre. In the year 2019, it was declared as a state cadre. Last page, you lordship, kindly see. Serial number 2, senior radiographer, state cadre. Your lordship kindly turn to page 6. No, my lord. Rule, my lord. Constitution of Departmental Promotion Committee. The Departmental Promotion Committee for consideration to the post of senior radiographer shall be considered with the following members, namely Director, Health Services Director. Director is the competent authority, my lord. The senior radiographer post is a promotional post and the competent authority is the director. CTO has no jurisdiction to transfer the petitioner, my lord. And second thing, my lord.
That has to be taken, but this order of transfer is a group transfer. Besides that, it is a mutual transfer, it appears.
My lord. That junior radiographer. No, my lord, not mutual transfer. No, my lord.
Or vice versa transfer.
Bye. No, my lord, he has no jurisdiction from CDM, my lord. And the second thing.
The CPN and PHO has no authority of giving the transfer as he is it as the post occupied by the petitioner, that is senior radiographer, is a state level post.
My lord.
Answer only the director.
Director, my lord. My lord.
The director health services is competent to transfer. And secondly, he has been transferred to a district cadre post.
District cadre post. In subdivisional hospital, post of senior cadre.
In the subdivisional hospital, where the post of senior radiographer does not exist.
My lord. My lord.
That the case, notice on behalf of opposite partner was one. Notice that you to be issued notice to the private party.
My lord.
If they are to be disturbed by the arrangement.
Okay. You to notice the speed post. It's a short denominated to opposite party number 5. Do you need any extra copies?
Not necessarily.
This is matter of
16th July. 16th July.
16th July. In the meantime.
My lord. When I approach Kali file kala pore ratri mate relief kar dile. I have challenged that in IA number. My lord, on the ground of jurisdiction, I have challenged, my lord. He has no jurisdiction, my lord. Your lordship will decide. My lord. If illegally. No, not supplied. But relief may be stayed if any illegality has been done by the authority. No, my lord. But no one has joined in my post, my lord. Not relief, my lord.
Under the circumstances, that will create some difficulties.
No, my lord. No, when I approach my lord, Kali file kala sai sai mate ratri relief kar dei chandi. 13 chot. Illegally they have relief, my lord. He has no jurisdiction, my lord. And ମୁଁ କୋଉଠି join କରିବି? It amounts to reversion, my lord. Demolition of. I am a senior radiographer.
Let notice go also in the interim application, so subject to final orders in the interim application, your lord.
What she says is correct. That
Yes.
It's a state cadre post and she has been given the district cadre post. Particularly when there is a no post of senior radiographer.
Had it been an individual case, the matter would have
No,
been.
only that post, only that post. Only that. So, in the meantime, operational. The order means 2024, it relates to serial numbers 1 and 2, the remains still. Further, the petitioner having already been released. The order date 24/6/2024. Relieving him. And the opposite party number 5 also remains still.
May I get my urgent certified copy in court of the day?
If not already given effect to, suppose they have already.
No, ସେଇଟା କଲେ back date ରେ ମତେ effective କରିଦେବେ। ସେଇଟା କଲେ ସେ
Suppose they have been released.
You have to go and join.
No,
They are given a-
no, join करें। ना join करें।
How is they give you that order? Once they have already released you, you are now hanging in midair. You have to go there and join, take charge.
No, my.
You are already signed
No,
exactly.
no, my.
So that is what
Nah.
I say, that is what he said.
My.
Supplementary list item number 33.
And my lord friend will be producing the certified copy of the order. Of the order before the order. Yes.
Maybe. Item 33. My lord, petitioner has granted interim bail for a period of 4 weeks, my lord. And it is going to be, my lord, stipulated period over 27/6/2024. He prays for some more time.
So item number 37.
May I please, your lordship? The alleged offence is under section 302. Initially, it was registered under section 307 and subsequently turned to 302, my lord. The prosecution case is that on 27/7/2021, the informal lodged a written report alleging that his doctor was working as a laboratory technician in Miller. No, भूल আসছে এটা না এটা ডিসপোজ হয়ে গেছে ভুল আসছে Miller?
Last order is the land transfer to the state is directed to obtain the case diary and the postmortem report by the next date of victim of the case for the.
এই কেস রয়েছে না
Dispose of it. That was dispose of order of my order case dispose of it. Order of
ডিসপোজ হয়ে যাচ্ছে আলিয়ার কেসটা ডিসপোজ হবে আগে আগে obliged.
So right now 39.
May I please? The present petitioner is inside the custody since 5/12/2021. Allegation, my lord, there is a quarrel ensued between the two employers regarding payment. It has been alleged in the affair while the injured was moving in the road. At that time, there was a quarrel ensued and the present petitioner threw some acid to him, for which he was sustained injuries on his person. That is the allegation. that can be borne out from the 161 and other thing.
Actually, affair with Ina.
Injury part, I have got that PP, my lord. My lord, I have only lifted where
View of this court regarding essay guideline.
that is there because a person is not getting that remuneration. And while he was being employed, demanded money. There is a correlation to that fact. And my limited prayer before Lordship for interim kept pending this application because my wife is only 15 days, my lord. I am not praying for money.
You know the mind of this court, very clear.
I am inside the custodian, my lord. Your Lordship is correct to that.
Let us see the injury report.
I've got that injury report, your Lordship, PP, which has been supplied. That is grievous and everything is there. On last occasion, also I have supplied. 2 persons named in the affair.
Face with both eyes.
My lord.
Eyes, face,
My lord, that is
other
there.
parts of the body also. Rejection lekha hai.
That is there. I do concede to that extent. Motor. Poisa delani COVID somere. 5/12/2021. Nahi bata.
That is a bad code.
No, bad code I cannot say. This is a very
Bad
beautiful.
code for this case.
Limited prayer for to look after my ailing wife. That much. The case on behalf of my client because he has been engaged me. Only limited prayer for that reason I have my first submission before Lordship, not for bail, only limited prayer. To look after the small kids, 2 kids are there small. And I am inside the custody 5/12/2021. Till today, trial has not been thought. God bless.
So that number 49.
49. Non-appearance on the records is
Yes, item 1. The contention that was raised in the first appellate court was by referring to the settlement records as Abada Jogya Anabadi as government land. And that is how the objection to the claim of plaintiff was raised. So that having been upheld, and the plaintiff suit has been concurrently dismissed. So the application of the Niranjan Makeup case as has been referred to by the first appellate court. Niranjan Makeup case may not be applicable. That of course I will have to check out.
I am closing it. I am closing it. Necessary file.
There is no contention as against the findings, but because of this principle of law, if I find that this doesn't apply, then I will give a short move.
They have 3 points.
Yes.
One is limitation. The other is the relationship between worker and employer.
Yes.
And third is
Yes.
all the 3 parts he has lost.
Within the course of this week, I will, if necessary.
Yes.
Item number 10.
If you want to argue,
There is nothing to have, nothing else to argue.
10.
I can tell.
When I'm here appearing on behalf of the respondent, my lord.
Anybody who is that?
For inclusion of party and copy has not been served on.
Now case. Take it up tomorrow again.
My lord.
For the day.
Item number 11.
There Mr. Sahu I have taken consent from my senior. He prays for tomorrow, or my Ronald senior prays for next week.
Monday.
Leave petition गुड़ा दिया है जी chapter 7 में. ये ना दिया जी.
Monday.
Sir को जो Monday.
I do not 12. I do not 13.
My Lordships, I am for the appellant, my lord. During pendency of the second appeal, my lord, the respondent number 2 and 7 have expired, my lord. 2 and 7, my lord. I pray only 1 week time, my lord, to take steps, my lord. On 4/1/2024, this was in the list, my lord. 4 months, 6 months, my lord. But yesterday evening, my lord, the appellant is 80 years, my lord. My lord, the appellant is 80 years, my lord. तो आपको आसिबी बोले आज सकाले ही मत फोन कर माय
And for the respondent.
oblige my
You mentioned 8 July na first.
Sorry, 8 July, yes.
Item 14. The notice was issued to respondent number 8 and 9. And 8 died.
8 died?
Respondent number 8 died.
That's right.
And she is the wife of Mohan Behera. And his son is already there at respondent number 10.
So there is no other leave LR?
No, no other LR.
So the sole surviving LR is on record?
Yes, my lord.
Sri Dayanidhi Mishra Learned Counsel appearing for the appellant submits that respondent number 8 has expired in the meantime. The sole surviving legal heir is already on record in the form of respondent number
10.
Respondent number 10. Stop. Hence, no further substitution is necessary. As regards respondent number 9, notice issued.
Notice was issued, but I'll correct.
Has returned unserved with the postal report within inverted comma, no such addressee. Learned Sri Mishra, Learned Counsel for the appellant, undertakes to file fresh requisites furnishing correct address of respondent number 9. Let the requisites be filed within 3 working days.
Yes.
7 days time. Notice be issued thereafter by registered post to the AD as the notice be issued thereafter as directed, fixing a short returnable date. Let's this matter July the last to Koro.
Commencing 29th July.
Commencing 29 July.
Item number 15.
Refused.
May I please your lordship? My lord, 10F did not back and 10G postal notice refused. So
10G refused, na?
yes, madam.
Notice issued to respondent number 10 bracket G has returned with the endorsement within inverted comma refused. Notice is held to be sufficient. Insofar as notice on respondent number 10F.
Yes, madam. I did not back.
The postal tracking report be tagged to the case record. Let's this matter next week.
My lord, as per instruction, appellant number 1A and 2 died, and respondent number 6, 8, and 15A also died. So, my lord, 15 days time.
Learned Counsel for the petitioner submits for the appellant submits that in the meantime some of the parties have expired. Steps for limitation for the deceased parties be taken within 2 weeks. Yes.
Item number 16.
No, the appellant number 1 died and 3 applications are there.
So you think that?
Nine. Limitation IA is 1398/20. File number 23 died on 27/10/2016.
When did you file?
In 2023. But the legal heirs are
allowed. This will be allowed.
Yes.
IA 1398. Hello. Even application for condonation of delay in filing the petition for substitution of respondent number.
Appellant number 1.
Appellant number 1. So it is submitted that the appellant number 1 is old and ailing. Appellant number 2 is a diabetic patient and also suffering from other ailments for which he could not instruct his lawyer appropriately at the relevant time. As such, there is delay in filing the application for substitution. Considering the grounds raised, the delay is controlled. The IA 1397 or 1396. This is an application for setting aside the order of abatement of the appeal in respect of appellant number 1 who died on 27/10/2016. It is submitted that the right to sue survives in respect of his legal heirs, the particulars of whom have been mentioned. What is schedule question na kon?
Yes, schedule. Page 3 of the
139
1396.
As per schedule to the petition. So, considering the above facts, the LRs of the deceased appellant number 1 be substituted in his place as appellant number 1A to 1D.
E.
E to nahi?
Yes.
A, B, C.
E.
Nahi, jano ko kati chinte pano. Dekho jano.
A, B, C, D.
A, B, C. Orchana Mahapatra. Tapar jo nata thila apna kati chinte.
Purnima Das.
Tapar Bono Dharana Mahapatra.
Bono Dharana.
4 জন hele. 1A to 1D. You are appearing for?
I am for the respondent.
So, appellate, you will continue to appear.
Yes. All right. I have already filed Bhinama of the legal heirs. I have to file the consolidated cost title.
Yes, consolidated cost. Yeah, order ta formal order.
It will be posted for admission.
Yes. You can admit it today.
Not ready.
Ready na?
Next week.
All right. Release this matter next week for admission.
Consolidated
cost to be filed. Item?
There is notice with me, correct, and that will be filed matter. There is note 2.
Admission is not staying there.
2, 4 and 9.
This matter was there before another bench, your lordship, much before vacation. My learned friend had assured the court that they will remove all these problems, all these defects. I am suffering this stay. Right?
You are appearing for which respondent?
I am appearing for Ramesh Chandra Das.
The respondent number?
Respondent number 1.
You want to appear for the other respondents?
No.
Learned friend.
No,
my learned
friend
senior friend, Mr. is also appearing for.
ଆପଣ ସାଙ୍ଗରେ
ନା ନା ମୋର ଗୋଟେ ଫାଇଲଟା ଯାଇ
କାହା ପାଖକୁ
ଟିକେ ଫାଇଲଟା
ମହେଶ୍ୱର ମହାନ୍ତି ହଁ
ମୋ ସାଙ୍ଗେ ମୁଁ ଆପଣଙ୍କ ସାଙ୍ଗରେ ଅଛି
ମୋ ସାଙ୍ଗରେ ଅଛି
ନା ମୋର କନସେପ୍ଟ ନେଇ
ହେଇଥିବ ଯାହା ହେଲା ଗୋଟେ ଦେଖିଥା
Respondent number 2, 3, 4 and 5.
2, 4 and 9.
No, last order also 2, 3, 4 and 5 in order to further pursue the appeal. What has happened? You take fresh notice, or if you can, any of you can appear, then end of the matter.
I am contesting. They are all my adversaries.
Achha.
So now question is, your lord.
So enter say dispute between the respondents also.
There is no dispute. I am the rightful owner of the property.
That is all right, but we have to regularize it. We have to bring it on record for hearing.
What I am suggesting and praying, your lordship, let him regularize it as soon.
That is what I am saying. That is what I am saying.
Without that, last time they assured the court that they will look into it.
Notice.
So say answer, sir.
Return.
Se ଜାଣିଛନ୍ତି ସେ address ନାହାନ୍ତି. They know their correct address. ନହେଲେ paper publication କରନ୍ତୁ.
Because he has filed a petition for vacation of order. We'll consider that. Notice पड़ जाओ तो.
Final hearing will be.
Final hearing को. Notice steps ने बनी जदी.
Steps it up return as my lord.
भूल एड्रेस दी थी.
भूल address दो.
सीधा पड़ा आने.
They are staying.
तो fresh steps ने बात कौन करे?
Fresh steps नहीं ना ये substituted service नहीं होता.
या पढ़ना substitute service करे थोड़े नीचे दे ना. Substitute service करी हो मना नहीं कि तो newspaper publication again that will take time. They will submit a draft that will be approved by the court and then तापर को खबर का publish करेंगे.
सर मुझे इतने जुक्ति करनी let them get it sufficient.
Yes.
लाभों की चीज़ नहीं ना no.
First steps be taken for issuance of notice on respondent number 2, 4 and 9 by speed post, fixing a short returnable date,
correct address,
requisites and furnishing correct address. Stop. Requisites be filed peremptorily. By requisites be filed by tomorrow peremptorily.
My lord, correct address will be obtained, my lord.
Within 3 days. Within 3 days. इसे दिन में कितना है वो अपन
correct address. सेटा दिए time लगे आगे चल. Within a week, man.
Within a week. Within a week. है ना? तापर लखन तो list this matter on
22nd July.
22nd July.
Interim order to continue.
Interim order to continue.
Item number 18.
No, item 18 notice was issued to all the respondents, but the notice issued to respondent 5 return saying that is deceased. My lord, can you see? So you have to take step. What happened? Can you see the cause title? I written during the pendency of the RFA by an order dated 15/12/2016. The law and additional justices assured held that there is no need for substitution. Hence, she is deleted from the case and no notice be issued to her because all his legal acts are all on record. No, will delete him. Will delete him. 3 sons and 1 daughter. It is already deleted by the order dated 15/12/2016 by the additional justices.
But anyway, appeal to set up पुने अपन revive करছে ना ताको अपना पक्ष करছে
वो लिखी जा रहा है लिखी जा रही है एक क्वेश्चन लिखी सीधा.
So respondent number 5.
My lord. I 1 to 4 their legal he have legal errors.
The SP Sarangi Leonard counsel for the appellant submits that respondent number 5 having died during pendency of the first appeal, the first appellate court directed her deletion from the case. Hence, no further notice need be issued to respondent number 5 or her, to the LRs of the respondent number 5. The other respondents are already on record.
1 to 4
have already entered appearance. And the suit is the appeal is otherwise ready for hearing. Their Satar appeal?
Admitted.
It has been admitted?
Yes.
On the date of that.
When shall we take it up?
Admitted.
When are you ready for hearing? When will you be ready for hearing?
August. August.
2 weeks after.
Is this matter? No, August and above.
August.
Is this matter on?
They commencing 12th August.
In the week commencing 12th August.
Well,
Item 19.
So notice appeal notice has to be issued to respondent number 4 to 6 and 10 and 11.
It was a hard on
Earlier issued.
I am for the respondent number 1, your lordship. In different benches, your lordship, it was hard on merit. But this type of notice was not there. But subsequently, today it was found that actually such type of notice there, is there. Even the written note of argument is submitted.
No. But we have to regularly meet.
Yes. You regularly see the respondent, it is about the present appellant executed a sale deed in respect of joint family property in favor of respondent number 4 to 6. So 4 to 6 are the purchasers. Now the sale deed of 4 to 6 has been declared void and decree of preemption is passed. Now at the stage is I have deposited the money for execution of the sale deed. Now the person who has sold the property, now he has filed appeal. But whose sale deed has been declared void, they have not come forward.
and respondent number 4
No, but unless he deletes them, and since
have
notice,
to remember that my lord, respondent number 4 to 6, they are the purchasers.
maybe.
They must be in the shoe of the appellant. Because credit has been executed by the appellant.
but since notice was directed to be issued without submission of notice, how can we proceed? Either we hold it sufficient or we delete them.
Earlier notice has been issued, no, my lord, though the fresh notice is directed to.
I don't know why it is a notice.
Kindly visualize whether earlier notice has been issued or not.
Yes, earlier notice was issued.
I have not yet notice on the 4 to 6 and R to 11 not served. So fresh notice now.
I will take fresh notice immediately.
You lordship, it's a sorted for the.
I will.
178 others are
fresh notice.
Therefore, I have in against respondent number 10 and 11, my lord, I will appear. I will appear.
Very good.
Appear. But 4 to 6 I cannot because they are the I am the plaintiff and they are.
Sri H.N. Mahapatra, learned counsel, undertakes to appear for respondent number 10 and 11. Let fresh notice be issued to respondent numbers 4 to 6 by speed post.
Yes.
Requisites for which shall be filed within 3 days. 3 working days per implement.
They are the handies of the.
List this matter and notice sufficient.
It's a solid so that because all the reviewers matter for disposal.
22nd July.
Diplo.
I don't know.
I have filed one IA for early hearing. Therefore,
it doesn't allow.
Diplo.
Please, my lord. My lord, there is a delay of filing this RSA. I have filed a delay application, condonation of delay. Compromise.
Yesterday we were making a mistake. Filing the consolidated after substitution. Consolidated cost title has been filed in the court. The same be kept under court. Heard Sri, who's the appellant? You are. Heard Sri M.K. Das, learned counsel for the appellant, and Sri. You said the parties were there?
Yesterday they were there.
Today they are not there. So we'll dispose it of.
Aye.
For the second time this petition is filed. Earlier the petition was filed person date. Thereafter again LRs have also.
So tomorrow will say that we have never compromised?
No. So legal.
All the legal.
So let them appear.
They were.
Kali ki tafi dunante kor daba.
Ta bhitare jane bedridden achi. Se.
All right.
Let's.
Kone fili last year? Kone na village entries? With the intervention of with the village entries and well-wishers. Stop. The details of the compromise. The terms of the compromise have been indicated under paragraph 5
yes.
of the IA. Stop. In such view of the matter, the second appeal is disposed of in terms of the compromise. The IA shall form part of the decree. Compromise petition shall form part of the decree. Agar register decree form part of the decree. Yes.
Item 22.
IA for dispensing with filing certified copy of Annex 2.
You have applied for certified copy in the court below?
Yeah, I have obtained also. What I in course of the I will.
So it is infructuous.
Yeah,
you want to file the certificate?
I have not filed today.
Learned counsel for the petitioner for the appellant submits that he shall file the certified copy of the interim judgment in course of the day. The IA is therefore dismissed as infructuous. The learned counsel is directed to positively file the certified copy in course of the day. Yes.
I pray for next week.
For admission. All right. Let's this matter next week for admission.
Okay.
23.
the delay of 5 years that I've explained.
Yeah, the limitation was issued on respondent 1, 3, 4, 8, 2, 4, 3, 5, and 6 not yet received. You are appearing.
I am afraid, Your Lordship, serial number, respondent number 1, 2A, B, and C.
ଅନ୍ୟମାନଙ୍କ ପାଇଁ appear କରିନାହାନ୍ତି?
ଅନ୍ୟମାନେ 3, 4, 4A and B, C.
କେବେ notice ଯାଇଥିଲା?
By registered post. Tracking report can be verified.
We will call for the postal tracking report.
Tracking report through it was issued through court, my lord.
No, by registered post with the
registered post.
So registered post ମାନେ tracking report ଥିବ.
Tracking report court ଥିବ.
No, postal ଇଏରେ ମାଗିଦେଲେ ସେ ଦେଇଦେବେ, direction ନହେଲେ ସେମାନେ ଦେବେନି. The office is directed
postal receipt number ଟା ଦେଲେ tracking report ଟା କରିବେ.
ସେ tracking report ଏମାନେ ବାହାର କରିବେ.
number ଟା.
ଏମାନେ ବାହାର ଅଫିସ ବାହାର କରିକି ତାକୁ ଟ୍ୟାଗ କରିବ. ଗୋଟେ ଫ୍ଲାଗ କରିକି ଦେଲେ ତାହେଲେ ଜୁଡିସିଆଲ ଅର୍ଡରଟା ପାସ୍ ହେଇପାରିବ. You are appearing for
1, 2A, 2B.
You have filed your वकालतनामा?
Yes, Your Lord. In court, already filed.
अच्छा.
Where to be?
Tell I mean postal tracking report regarding regarding service of notice be tagged to the case record. Is this matter next week? Next week ଆସିଲେ ସେ ଆସିବ.
Item 24. Deep progress.
90 days, Your Lordship.
Notice was issued?
No.
All right. IA 621 of 2024. Issue notice on the question of limitation to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter after service of notice. चीज करो देखो
Item 25.
pass over.
Item not 26. 26 in this case, my lord. I am for the OP, my lord.
Petitioner ना तो कौन करे pass over.
ଆଜ୍ଞା now ଗୋଟେ
week सारा ଅଛି ନା?
ଆଜ୍ଞା ଆଜ୍ଞା
yes
tomorrow
ना तो खाली भी रखा हो.
ଆଜ୍ଞା ଆଜ୍ଞା
Item 27.
27, I am for petitioner, my lord. I have filed a transfer petition from the Court of Family Court, Nabarampur to the.
Mr. Raut was present here. Surod Raut is appearing for the other side.
Get out again. Nahanti, opposite party.
Somebody has appeared.
Opposite party has filed a section 9 petition, my lord, and for that petition, I filed transfer petition.
Both sides are not there. How can it be? This is a final disposal. Pass over. Pass over. Kali pass over for the day. Yes.
Item 28.
minutes, I have appeared for the opposite party. In the meantime, both husband and wife, they are staying together. Virtually, it has become infectious.
But if the petitioner is not there, how can I pass that order? Please inform him so that order, I am just passing it over for the day.
Tomorrow you will see.
Pass over for the day. मैंने खाली order रखा है.
Item 29.
29, Mr. Hon'Ble was here. I saw him. Shut up. 30. Hey, Mr. Hon'Ble is there. Yes. Mr. Hon'Ble, unmute yourself. You are muted.
Millers. I was there. Urgently, a camera. I didn't expect that it will use. It can be passed over, or I'll take instruction.
All I did is passed over. Passed over for the day tomorrow.
Millers.
Please inform Mr. Mishra who is applying for the other side, so that it can be disposed of. Yes, item 30.
Item 31.
31. Chada.
Item 33.
31 ରେ ମୁଁ opposite party.
के नाते petitioner के नाते हो तुम will have to pass it over for the day हो.
नहीं next week ଆସିବ. ନା ନହେଲେ ଥାଉ.
ଆଉ ଦେଖିଆ.
Item 33.
ସେଟା କଣ ନେଇଗଲୁ ମୁଁ ଦେଖିକି ଦେବି ତାକୁ
Yes, item 33.
Next item.
34.
देखो
Item 34. 34 no instructions, sir.
will dispose of
Yeah. Nice, Sudhit.
Sri S.K. Sorangi learned counsel appearing for the petitioner submits that he has no instructions in the matter. The transfer application is therefore disposed of. Yeah,
Item 35.
My lord, on behalf of Mr. Viraja Krishna Das, my lord, actually we have lost the files. Kindly grant one time.
Place this matter next week as prepared for.
Item 36.
Lordship, on behalf of Mr. A.K. Pandey, Lordship.
Who is for the other side? Who is for the other side? Allow me the final disposal matter, the other side not speaking to pass over. Inform him. Yes.
37.
37, 38.
Same jinso Mr. Mahapatra. The other side is Mr. Godi is there. Other key inform kar do.
Next week.
Next week I call you. Jit petty. Very good. Will dispose of. No.
No, only submission my lord direct to no seeking adjournment.
Yeah, final hearing kar do like na. You will finally hear the matter. Are you not ready? Why?
I am the opposite party.
Opposite party की बोलते क्या जाऊँ ची? कि ताको petitioner से जाको जाता कोई अपने जाको जाता कोई ready? Or tomorrow कल ही body रखने को कल ही will dispose pass over.
41.
Public.
चलो.
Item 42.
इन कितने हैं? चलो कौन चलो.
Item 43. Item 44. Item 45. Item 46.
56 में I am for 56 बहुत कष्ट रे मोबाइल फोन दा फाइली से पुणी नॉट रिचेबल no instruction with liberty to file.
No instruction.
Item 47.
Yes.
Item
Mr. Mishra.
48.
Oh, 48 is such.
Item 48.
Other side की ना थी.
petitioner
चल wait करिए. क्या करें?
advocate change करचुन actually without consent right. There is a noting. There are two sets of advocates.
Sir, somebody must appear before me. Nobody is appearing. Okay, oh, pass over. Pass over for the
order का ना she actually instruction किसी ना है
next week कर दे.
next week.
Item 49.
compromise जो सुन जाएगी but authenticate.
49 भी से.
Item 50.
चलिए घोड़े जो.
Item 51.
Same. कितना आते हो कौन कहते?
Next week.
Next week.
Interim order will next.
Interim order to continue.
Item 52.
Suppose yeah. Anybody here?
56.
56, Mr. Patnaik, if the other side is not there, I cannot dispose of.
But no, because I have to take a leave of this honor court because it was wrongly filed here. It is within one sessions division. I pray for transfer of the proceeding from Banpur to Bhubaneswar. So may kindly see the prayer. Page 4. One CC case was is pending with JMSC Banpur to the court of SDM. My prayer. It is within one sessions division.
The sessions court is competent to do
So
that.
I have to approach that court. Wrongly I filed it.
Learned counsel for the petitioner seeks permission to withdraw the transfer application with liberty to move the court of sessions with the same prayer. Permission is granted with liberty as aforesaid.
Item 57.
Sure.
Item 58. Item number 60.
Both sides go through Ashanti.
Pardon, item 43.
म्हणजे आपण एकुटे आलो कोण अदर साइड
Lucky happier both perhaps nobody has happier.
नाही नाही पिअर्स होईल रे फायनल डिस्पोजल मॅटर
Item 60. Item 61.
My lord, I pray for tomorrow.
पासवर
Item 62. Item 63.
60 I am for the opposite party, my lord. Infructuous elect.
केंद्री
Sir, divorce allow he needs family court.
नाही I cannot pass this order on your submission.
My
I'll have to wait.
Again.
If it doesn't appear on Friday, we'll dispose of.
my lord.
Series ହେଇକି dispose of ହେଇଯିବ ସବୁଦିନ ଡକା ହବ ତାପରେ
Again.
Item 64.
most of them must have become infructuous actually ନାଇଁ କି
Item 65.
65 also. my lord.
same pass over.
Item 66. Item 67. Item 68. Item 69. Item not 70.
70 I am for the opposite party.
Item 71. Item not 72. Item 73.
ଇଏ ମାରୁଛ କମ୍ପ୍ୟୁଟର ମାରୁଛ ଡିସପ୍ଲେ ରେ ଦେଖୁଛ ତ
Item not 74.
ଇଏ ଆଉ 2023 matters ଗୁଡ଼ା
74 kindly carry on next week. In the last week, Lordship had this matter. We wanted to see the map. I have informed the party. They will come on Sunday during the map.
Hold on, next week as well for
74.
Item 75.
75 to pray for a passport for today, my lord.
Item 76. Item 77. Item 78.
ये कौन ऑर्डर से रही नहीं तो कौन से रही हियरिंग ऑर्डर ऑफ डिवन अच्छा अच्छा item 78
is for fresh admission.
78 yes yes sir what is this matter
The trial court dismissed the suit. In appeal, first
you are the plaintiff
I am the defendant.
you are the defendant so this is against the confirming or
Reversing.
reversing judge
Reversing. Trial court found that the suit lands being agricultural lands and some other properties is hit under section 40 of the OLR Act, and therefore there cannot be any alienation or partition. Appellate court didn't touch that.
you suit for partition then what happened
Since the suit properties were the agricultural lands, the trial court found, but under the OLR Act, such a suit is not maintainable. Section 40 is a bar for partition. So then they file an appeal. In appeal, without touching that finding, what the appellate court has said, since the partition was between the father of these parties, and thereafter the sons of the parties are also entitled to the share, therefore the partition can be granted without touching that point. Therefore, I have filed the second appeal. I think ground number 1 was that.
let me see where is that finding of the trial court
Just getting the file. Just, I have extracted that finding in my appeal grounds also. That paragraph, I have extracted.
let me check so the parties had a land in excess of ceiling area and hence as per the provision under section 40 of the OLR Act, no suit for partition can be filed without written observation. So the first appellate court
Appellate court didn't touch that point. What it says that since the partition was in respect of the father and brothers, and therefore for children, such a bar is not there. But he didn't discuss on this aspect, not set aside this point.
Without considering the effect of section 40 of the OLR Act. Got it. Let's see, SS Raul and senior counsel appealing for the appellant. Appellant. Produce the impugned judgment. Impugned judgments. Considering the grounds raised, the second appeal is admitted on the following substantial question of law. One, whether the first appellate court was correct in reversing the judgment passed by the trial court without considering the effect of section 40 of the OLR Act. Issue notice to the respondents by registered post with AD. Returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. LCR दरकार. LCR इधर कौन दरकार? This is purely
Point question of law.
how LCR नहीं है इसमें. LCR better. No, call for the LCR. Is this matter? In the week commencing 12th August.
Ross may say that liberty to raise other grounds.
No, you need not say. We can raise.
Item 79.
Pass over.
Item number 80.
Pass over, chalo.
Item 81.
81, yes. Item 81. Shut up. Pass over.
Item number 82.
Yes.
82. Sorry, I couldn't get the file.
I'll pass it over for the day.
Let it be on Monday, Maharaj, because the client is coming, has already talked to me. After 20 years, he's coming.
After 21 years, this matter has been listed, so naturally he'll come.
Some material instructions.
Oh.
Hoping for some material
Yes.
instructions. That's on Monday.
As requested by Sri P.V. Balakrishna, list this matter next week. I think we have to delete the name of your senior, isn't it?
How?
Okay. Does this matter? Next week, we commencing
Item number 83.
82 and 90. Both.
Item 83 and for the respondent.
Mr. Mishra, SP Mishra is. So what? Yes.
My lord, I am in 90, my lord, for the.
90
I
Item 83.
If your lordship allows me to note the substantial question that has been framed, my lord.
Please.
My lord.
Look at the file and do that. 84. Item 84.
Item 84. Item 85.
85. Mr. Mahathi was here. I've seen him.
The first hour.
First hour associate Oh, pass over.
Next week,
Next week.
Item 86.
Item 86. Pass over.
Item 87.
चलो और
Sir. Item 88. Item 89.
89 my lord,
Tomorrow your lordship, due to some difficulty, Mr. Satpathy will.
Pass over for the day.
Sir, thale tomorrow rakhunto ne next week rakhunto.
All right. Next week as paid for.
If he is praying for adjournment, let it be next week.
Item 90.
More than 73
90
is there.
Yes, 90.
Yeah, for the
my lord, may I pray about this matter to be taken on Friday, my lord? Can I pray?
No, I think Mr. Balakrishna wants it to be. He is praying for next week. We'll take it up next week then.
Yes, my lord. Yes.
Next week your lordship 11 July 11-12 टा मत छाड़ी क्या होते 11
Hey, next week the पूरा आशो जो ना हो.
My lord, 173 item as senior is there.
73. देखो करो. Option ये तो करो आप. You are ready. Very good. You are the appellant.
Appellant.
It was called out.
My lord,
It was called out. Why didn't you say so?
my lord, I
when I was coming, your lordship had
Oh,
crossed it.
Okay.
Well, I
73.
didn't want to disturb in.
Next solid 73. LCR ଅଛି
ନାଇଁ ଏଟା limitation condone କରିଦେଇଥିଲେ.
admit ହବ
ହଁ.
No, degree has been condoned.
Yes.
Admission ରେ ଖାଲି ହବା କଥା.
Well,
Admission ହବା କଥା.
admission. Well, the plaintiff is against a confirming judgment. Well, plaintiff filed the suit.
ଏଇଟା ବୁଝିଲେ ଏଇ ସେକେଣ୍ଡ ଆପିଲ ବେଳକୁ ଆମେ ହାର୍ଡ ଫାଇଲ ଦେଖିବା ଏଥିରେ ଏମାନେ ଜାଣିନାହାନ୍ତି ଏମାନେ ଏମିତି କଣ କରୁଛନ୍ତି କୋଉଟା କୋଉ ଜଜମେଣ୍ଟ ଦଉଛନ୍ତି ଜାଣିବା କଷ୍ଟ ସ୍କାନିଂ ପୁରା ଭୁଲ CS 9134 of 2015 yes then all ସ୍କାନିଂ ରେ ମେଟା ଡାଟା ଅଲଗା ଲେଖା ହେଇଛି ଏଇ ଜିନିଷ ବାହାରୁଛି ଅଲଗା ଭାରି ଅସୁବିଧା ଆଜ୍ଞା
मतलब the
shoot for partition what is the ଆଚ୍ଛା ହଉ କଣ what happened the suit was dismissed okay
confirmed in appeal. मतलब the
dismissed on the ground
your lordship will see the issues at page 20 running page 23 of my lord's brief.
23 yes.
Whether the suit is hit by principle of res judicata, whether the suit is barred by limitation, and whether the plaintiff is entitled for a preliminary decree of partition as prayed for.
Res judicata ମାନେ ଆଗରୁ prior petition ଥିଲା କି?
Yes, that issue I'll just place before your lordship. That is issue number 3. My lord will see the next question which is required to be answered is whether the suit is hit by principles of res judicata. The pleading as well as the evidence of PW1 is silent about any former suit between the parties to this suit. It is the defendant who pleaded about the former suit which was filed by the defendant's father against the plaintiff and others. Thus, therefore, the burden of proof lies on the defendant to prove the suit is hit by principles of res judicata.
କଥା କରିବେ ଟିକେ kindly ଯଦି if you don't mind if you can please this is a serious matter sir. Yes.
DW1 stated that the plaintiffs have obtained 2 void sale deeds from Vijay Lakshmi Bhagat and alienated portion of his DW1 plot number such and of Sabik Khata number such and such to different person by executing registered sale deed marked as exhibit such and such. When the plaintiff and their purchasers created disturbance in the peaceful position of his DW1 father, his father filed title suit number 168 of 84 in the Court of Civil Judge Seniority in Bhubaneswar for declaration of right title interest, confirmation of possession and other consequential relief. DW1 proved the certified copies of order dated such and such and DW1 proved the judgment passed by the subordinate judge in title suit number 168 of 84 as such and such. DW1 proved decree passed in title suit number such and such from exhibit somewhere. It appears the defendant's father had filed title suit bearing 168 of 84 in the court of subordinate at Bhubaneswar against the present plaintiff and others for declaration of title, confirmation of possession along with permanent injunction. The present plaintiffs were impleaded as defendants 2 and 3 in this title suit number 168 of 1984. From the exhibit such and such, it appears that on 11/8/86, defendants 2 and 3 plaintiffs had filed a petition to time file a written statement, but they have not filed Vokalatnama. The lordship may kindly mark this. On 23/1/86, Vokalatnama and petition for time was filed and WS was filed. On 19/8/87, defendants 2 and 3 were all set ex parte. Exhibit such and such revealed that the TS number such and such was decreed ex parte against all the defendants. In the result, the right title interest of Gajanand Agarwal, father of the present defendant, over the suit land was declared. That was, my lord, for declaration of right title interest on the basis of the sale deed, which was decreed ex parte. This is a suit where I am seeking partition. Even if, my lord, my decree of I am not related to Gajanand. Gajanand Agarwal is father of the present respondent. They filed a title suit for declaration of right title interest on the basis of the sale deed. Even if it is accepted for the moment that suit was decreed ex parte. But now it's a suit for partition. Whether the declaratory suit on the basis of the sale deed will stand as a res judicata in a partition suit.
Why should it not stand as a?
It will not stand because, my lord, there was a determination of question whether he is the owner of the property or not on the basis of the sale. Here I am claiming partition of properties which stood in my name and in his name. The property stood in his name. I filed a suit for partition that I have.
No, I will ask you to pause for a moment and to answer one question. What is the relationship between the parties that becomes very, very.
They are nobody. They are not blood relations.
May not be blood relationship. But how can you claim partition? On what basis are you claiming partition?
I am claiming partition on the basis that the property originally stood in name of my ancestors. Some portion of the land was alienated by my ancestors in favor of them. Yes. That is
that title has been declared in his favor.
Title has.
With your lordship, no, all wrong statement, madam. All wrong statement.
Yes, sir. See the disturb. No. Even admission of the second appeal, I was telling that the respondent has no role. The respondent cannot even utter a single word.
Decided by Supreme Court by my lord, I think Agrawal or that if the respondent is APR, it is the duty of the court give an opportunity to see whether there is a substantial question of law or not.
Anyway, let us see. Let him complete.
But it will not be ancestral property either of Gajananda or his or
I will look at the judgment. Yes. So what happened?
Then the lordship may see that.
So that the title was declared in favor of Gajananda. You need to challenge it.
No. That I have not challenged.
Okay.
That is not challenged.
So how on what basis you do?
I filed a suit. Claiming partition of those properties, saying that it belongs to our family, and the declaration of title in respect of one portion cannot stand as a bar for me to file a suit for partition. Yes, the bar comes, your lordship is correct, because the bar comes because a suit decree is staring at me unless it is.
But can that portion of the property which stood recorded or which was declared in favor of Gajananda Agrawal, can it be included in the hotspot?
My lord, here the question is.
My question is very straight.
Yes.
My lord, you are asking for partition?
Yes.
Can that portion be included in the hotspot?
That portion cannot be. That portion, in fact, cannot be. My lord, because there is a decree staring at me. That I should fairly consider.
Yes.
Now the question is, my lord, this issue, your lordship will kindly see, he proceeds on the notion, your lordship, I just place that portion. From the above mentioned documentary evidence, it is clear. Sir, जो exhibit A था, तीनटा A
Code page ta कौन?
Sir, page 27.
27. Okay.
From the above mentioned documentary evidence, it is clear the present plaintiff were appeared in the former suit filed by the father of the defendant to declare his right title interest over the suit land along with other reliefs, but subsequently they were set ex parte. The present plaintiff preferred not to raise their right over the suit property in that suit. They have also filed claim partition in suit by way of counterclaim. According to the explanation 11 of CPC, any matter which might and ought to have been made ground of defense or attack in the former suit shall be deemed to have been matter of. Yes. This is the point on which the suit was dismissed. My lord, fairly speaking, this decree stares at me. So once that decree stares at me, unless I would have challenged that decree, it will not be there. My lord, I should stop somewhere. I know my limit. My duty is to my.
The client has given you a brief.
I have to do.
You have to place it. Concurrent finding or कौन?
I leave it to election.
अब कहीं कहीं कौन?
ना किच नहीं.
इस शर्त दे भी.
खाली अगर फैक्ट का मिलान फ्रेंड.
कौन होगा?
ना हम खाली एक राउंड.
consequences है ना
चलेगा. उसे कथा कहू नहीं. अगर प्रॉपर्टी टा थिला ब्रिजलाल भगतଙ୍କର से मरी गले तीन पुओ को छाड़ी की. जगन्नाथ भगत मरी गले तांका विडो आ 3 वर्षर झियो को छाड़ी की. मोनी मालती देई होची तांकर स्त्री. मालती देई along with her daughter and other 2 sons of ancestor sold the land to this Gajananda Agrawal 1966. But thereafter, this minor daughter Lakshmi, Vijay Lakshmi in 84 sold the entire land to these appellants. Thereafter, they sold it to more than 40 persons. Every documents are executed on his admission. Much thereafter, when they created disturbances in our possession, 84 suit was filed for declaration, confirmation of possession, and permanent, that is decree. That I have my unfriended said. That
Yes, fairly admitted that.
yes.
Fairly admitted.
Yes.
I'll dismiss it. Heard Sri A.P. Bose.
Once I accept the brief, my lord, I have to address the.
No. You are
limitation.
No, that is a different matter. You have very fairly said, I asked you 2-3 questions. What stuck to my mind?
Yes.
I asked you and you answered it fairly.
My lord, when I drafted it, I asked him. I said, why are you filing this case? He said, no, you file. I did my duty.
Heard Sri A.P. Bose, learned counsel for the. I need not hear you, Mr. Bag, or should I?
My presence again, immortal Marion.
No, I have not problem.
Heard Sri A.P. Bose, learned counsel for the appellant, and Sri Vansidhar Bag, learned counsel.
Sole respondent.
Appealing for the sole respondent. This appeal is directed against a confirming judgment passed by the District Judge Khorda in RFA number 41 of 2021, whereby the judgment followed by decree passed by learned এই দেখুন তো এই জিনিস তো প্রবলেম হচ্ছে পুরাটা পাই মতে এখানে পুরাটা আউটসাইড মারা দেব পুরো মতে পুরো হার্ড ফাইল দেব হলা দরকার নেই মুই করে দেখো পুরা একদম লাস্ট মতে মারি মারি ଯିବାକୁ পড়িব passed by learned first additional senior civil judge Bhubaneswar in CS number 9134 of 2015 was confirmed. The present appellants. You are the appellants.
My lord, I am the appellate.
Sole appellant. Okay. But you have to help me because this is totally wrong stand. So every time I have to go.
I'm assisting. My lord, civil judge, senior division, first additional senior civil judge.
Semani se jo Raghunath Patra, Sushila Patra.
No, plaintiffs. They are the plaintiffs. But before your lordship, Raghunath Patra has come up because Sushila Patra in the meantime had expired.
Has expired.
In the appellate stage, Sushila Patra was dead.
I'll mention it somewhere. All right. The suit was filed by the present appellant and one Sushila Patra for partition of the suit properties. Said Sushila Patra died during pendency of the appeal. First appeal. Stop. The suit property pertains to Khata number 122, plot number 588, measuring an area of acre 13.940 decimals of Mouja Bhagavatipur, recorded in the name of
Brajo
Bhukanlal. Stop.
Page 21, if your lordship may see it.
That is what I am writing.
Yes.
Here, TK खाली briefly लिखे जाओगे ना. After death of said Brajo, the property devolved upon his 3 sons, namely Ramlal,
Chaitanya Prasad, Jagannath Prasad,
and Jagannath Prasad. Jagannath died prior to 1966, leaving behind his widow Maruti Devi and minor daughter, namely Vijay Lakshmi. Vijay Lakshmi, after attaining the age of majority, demanded her share, and in an amicable settlement, she was allegedly forced to take the suit land as her share by relinquishing her right from the other joint family properties. Vijay Lakshmi sold the suit property to the plaintiffs by RSD number 534 dated 1984 with delivery of possession. Since the defendants what is the cause of action? It clearly likha hai. Probably you had wanted to,
Yes.
when such possession was threatened by the defendants, the plaintiffs demanded partition of the suit land by metes and bounds, which being refused, the suit was filed. So, the sole defendant contested the suit by filing written statement, inter alia challenging its maintainability on the ground of res judicata, limitation, non-joinder, etc. It was specifically pleaded that the father of the plaintiff, namely Gajanand Agarwal,
Father of the defendant,
namely Gajanand Agarwal, had purchased the suit land from
Ramlal, Chaitanya, Malati and Vijay
Lakshmi, while arrested dated
13/9/1960.
Just 13/9/1966, followed by delivery of possession. Stop. The property was also mutated in his right. When the present plaintiffs allegedly caused disturbance in his possession, he filed a civil suit being CS number 168 of 1984. TS 1984 TS number 168 of 1984 in the court of senior civil judge subordinate judge
भुवनेश्वर फाइल ना सर फर्स्ट एडिशनल को ट्रांसफर होला
सर
1968
सूट
ना
84 सूट
सर ना
भुवनेश्वर सेतल सार कहउछन जे सेतल सबऑर्डिनेट जज थिला सिविल जज सीनियर सबऑर्डिनेट
सी इलेक्शन जो सीनियर सिविल जज इलेक्शन बदन नथला सब जज
दैट टाइम इट वाज सबऑर्डिनेट जज
CS number 168 of 1984 in the court of sub judge Bhubaneswar for declaration of his right, title and interest. Said suit was decreed in favor of Gajanand Agarwal. After death of Gajanand, the defendant inherited the suit land and converted it to homestead as per the provisions under OLR Act. Stop. The trial court framed several issues for determination, including issue number 3, which was as follows. After analyzing the oral and documentary evidence adduced by the parties, the trial court, hey, Mr. Mishra, ठीक आस्ते कथा था करना दे, आपन को, ठीक है, slowly कथा था कर दो. The trial court, taking note of the decree passed in CS number 168 of 1984, held that the suit was hit by the principles of res judicata. Further, the plaintiffs never raised any right over the suit property, despite being implemented as parties, for which the suit filed by them subsequently was also hit by the principles of res judicata. Other issues are also, we don't have to refer to other issues. I think this is the main issue.
लिमिटेशन लंका भी डिसमिस है लिमिटेशन पे भी
The suit for the trial court further dismissed the suit on the ground of limitation. The being aggrieved, the plaintiffs carried the matter in appeal to the district court. Learned District Judge, as per judgment passed on 10/4/2023, did not find any justified reason to interfere with the order passed by with the judgment of the trial court. It was held that the plaintiffs, not having challenged the judgment and decree passed in TS 168 of 1984, the finding of the trial court that the suit is hit by the doctrine of constructive res judicata holds good. The other findings rendered by the trial court were also confirmed. The appeal was therefore dismissed. In course of hearing on the question of admission, Sri A.P. Bose, learned counsel for the appellant, has forcefully contended that the finding of both the courts below that the suit was hit by the doctrine of constructive res judicata cannot be sustained, for the reason that the plea of partition was never raised nor an issue in the previous suit. Stop. After considering the submission as above, and upon going through the findings of the courts below, this court finds that the earlier decree, the decree passed in the earlier suit was in respect of the suit property, which is sought to be partitioned. Stop. The plaintiff appellant and plaintiff appellant had never claimed partition in the earlier suit, nor challenged the decree before the higher forum. Stop. The decree so passed, therefore, stares at him. Stop. In such factual scenario, both the courts below committed no error in holding that the suit is hit by the principle of constructive res judicata. This court fully concurs with the findings rendered by the courts below, and therefore finds no reason to interfere therewith. Stop. Moreover, there is no substantial question of law to be determined in the present appeal. Stop. The second appeal is therefore dismissed. There shall be no order as to costs. Yes.
Lord, once this is over, I should fairly say, when Sushila died, the legal aids were not brought on the record. The first appeal otherwise was incompetent also. But why didn't they challenge it? That is the problem. But whatever had they challenged it, then they would have at least got some, and now one more thing in the suit, my lord, when it was drafted, I asked him. ଆଉ ସେ ଯୋଉ ସୁଟ୍ ଟା କଲେ ସାର୍, ସେ ଯଦି ତାଙ୍କର ପ୍ରିଭିୟସ୍ ଯାହାଠୁ କ୍ଲେମ୍ କରୁଛନ୍ତି କିଣିଲେ ବୋଲି, ତାଙ୍କୁ ବି ଯଦି କମ ସେ କମ ପାର୍ଟି କରିଥାନ୍ତେ, ଗୋଟେ partition suit somehow I could have made out an arguable case.
Okay, I will, while finalizing it, I may add that non-joinder thing also.
Yes.
And limitation thing. 1 or 2 lines I may add.
ଆଜ୍ଞା ଦେଖନ୍ତୁ ଟ୍ରାଏଲ କୋର୍ଟ ଲାଷ୍ଟ ଏକ୍ଜିକ୍ୟୁଟେଡ୍ ଡକ୍ୟୁମେଣ୍ଟ ଓନ୍ଲି ଯୋଉ ଓକିଲ ନୋଟିସ ଗୋଟେ ଦେଇଥିଲେ ସେଇଟାକୁ ଏକ୍ଜିକ୍ୟୁଟ କରିଛନ୍ତି, ଆଉ କିଛି ଡକ୍ୟୁମେଣ୍ଟ ନାହିଁ।
Anyway, so that's all.
ଆଜ୍ଞା।
Aji ko jayega. This court appreciates your effort, Mr. Boss. Ko jayega. 91 to rukha.
Unless we draft a suit or WS in the proper way, nothing can be done.
Civil suit pleading.
Pleading is important. Like at least he should have made them the parties that vendors man ko thali bhi aenge mu gote case try present kari parda. Ethi aenge mo dita hatta manda thousand juddu karo. And that to be fair your lordship.
Moru ko kange asila ya.
Aya ame aya कहना उचित न.
कहरे तो बहुत कथा कह जाई परिबो. Yes.
500 भरेतले.
पासवर्ड पे इखना कोन नबा. अब निवर्ती पिटिशनर. अदर साइड अछंती. आतन पासवर्ड खाली काली पासवर्ड पर ये आसिला कुछ शुक्रवार दिन सब सीरीज के काटी देबी. कि आसीबन जदी 2000 पुराना मैटर किछि रखिबिटी. मु विषय दिलो. पुराना मैटर मैं कह दोची द बार मस्ट कोऑपरेट. किछि रहबो नै जदी आपण अपेयर करबे टाइम नेबे जदी किछि अछि अलगा कथा न होले डकाव शुक्रवार जाय तापरे से चली जिवे.
Pardon your lordship, item 52 infrastructure.
77 number. More 77.
Infrastructure.
77.
52 dismissed as infructuous. Yes, somebody else? कौन तो?
Your lordship.
कौन तो? Please कौन तो?
Your more 77 number.
77 कौन है? पास ओवर है काली फोन डकावो.
काली डकावो सर.
है क्या? 77 वन सेकंड अपील.
हाँ नहीं अरे से
सेकंड अपील मैं वर्चुअली सुनिबेनी क्षमा करियो मते. वर्चुअली आई विल नॉट अलाउ वर्चुअल. आपको फिजिकली अपील करबो पड़ो. फिजिकली अपील करो वर्चुअली मैं सेकंड अपील सुनि परिबेनी फाइनल डिस्पोजल. हां छोटो कटिया ऑर्डर्स पड़ोस अछि सुनि देबी. सेकंड अपील वर्चुअली आप आधा को तो आधा सुनो तो इखना तो कहले तीन थल.
टाइम किछि दियंतो.
हाँ टाइम दो नेक्स्ट वीक
इट इज जुलाई
अलाउ डेट कर दो.
Commencing 8th July.
Commencing 8th July.
Item 94. 94 at 2 weeks after.
94 खाली तो काम कहीं व्यस्त हो जाओ. Yes, Mr. Das.
नहीं हम पासवर्ड की आसी होता कोई
पासवर्ड का काम करे.
मैं दौड़ी के आस्तु.
94 खाली तो काम रेडी कैसे हुए. नॉट डिसमिस कर देंगे.
नहीं तो हस्बैंड तो जानो. I am for the respond. Always ready.